In this item also.
You want your name to be recorded?
No,
That's fine.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 6, my lord. So we have, my lord, filed the affidavit today, my lord. Already a copy has been served, and moreover, we have also filing the interlocutory application citing the ground of delay, my lord. So, my lord, we have submitting the requisition slip to the court master so that they can
Yes, get it.
also.
May I place your lordship? So item number 10 become infrastructure lordship. May dispose of.
Okay. Both says it duly represented upon instructions. SP Sarial and counsel for the petitioner
Item 10 is
submits that the matter has become infructuous. Accordingly, this matter stands closed, having been rendered infructuous. Okay.
I'm for the five, respondent five.
Okay. Your name, you want your name to be recorded?
No, ma'am.
No, it's okay.
All
Outside the representative said.
Obliged.
Item number 5 for admission.
Yes. Mrs. Vora, you have explained to the officer the
Yes, lordship.
discrepancy.
Yes, lordship. There was a mistake, lordship. Initially appointed in Rajgarh in school, but in that school there was no Boro medium post. So he requested a private respondent to appoint him in another school. So on same date, on same issue number, earlier director has some mistake has been done. Attached him to Uttar Sekhar ME school, lordship. Kindly pay this our. There is a mistake, lordship. He is the officer, lordship.
Okay. Which document you want me to read?
Lordship. Issue number given same, that is the problem, lordship. Subsequent case is his application, respondent number 5's application. Respondent number 9, sorry. This is the another letter order with same issue number. Which
This
That-
mistake should ought not to have happened.
lordship. I
There
am
cannot be
extremely
two
sorry.
orders with the same.
Yes, lordship.
Okay. Please file an affidavit to bring on record this
Lordship,
discrepancy, but otherwise on record, we will have the same thing.
lordship.
You are,
Anurag Goel, Principal Secretary, BTC.
Acha, Mr. Goyal. Especially in this education matters, Mr. Goyal, we are finding that your affidavits are not on time. There's a, what you call, in many cases, your affidavits are not there. So I think now we have this on the online portal. You can have it, your department registered, and you will get all the information. You can have the orders also on your table, number one. Second is that you can send your officer to the your standing counsel. Have a list of those cases where affidavits have not been filed. Because in many matters of 2000 up to 2019, it's not one solitary case that for which we are pointing it out. There are many cases where affidavits have not been filed. And for small petty matters, these school teachers, instead of teaching, they are spending their time litigating. So
Okay.
please see that the system is put in place so that you need not intervene on each and every case. Because this calling of officers is not something we do it by to have some satisfaction. It is only to see that these discrepancies must be explained. Correct?
Sir, actually, in this case, there was a clerical mistake on the part of the.
No, it's
director.
okay. And for that, I'm not putting you to task, but what I'm trying to tell you is that in this, especially BTC matters for education, please see that some system is put in place, and the affidavits which have where in cases where affidavits have not been filed, please ensure that at least in 2 or 3 weeks, those affidavits are filed.
So we'll ensure, madam.
Okay. So see, we have been called only for this petty thing. Okay, that's right. Let him file an affidavit to pay for this mistake. And Mr. S. Upadhyay, and counsel for the petitioner. Also had Ms. R. Boroboral and standing counsel for BTC. And for,
Respond number 9, Lords,
okay,
private response.
okay, Mr. H. Sharma, then counsel for respond number 9. And for elementary education department, you are there. Okay, Mr. P. Bora, then standing counsel for elementary education department, appearing for respondent numbers 1 and 2. For BTC is 3 to 7. And Mr. Sharma for 9. Next, pursuant to order dated 15/3/2023, Mr. A. Goel, Principal Secretary for BTC, is personally present. And he has explained that on the request made by the respondent number 9, his appointment to Rajagar, RAJAGRH, ME School was recalled, and by a letter mistakenly issued, mistakenly passed in the same issue number, the respondent number 9 was appointed at Rajagar, RAJAGRH, ME School. Next, on such explanation been tendered, the court permits an affidavit filed by the competent authority of the respondent numbers 3 to 7. To explain the discrepancy So the personal appearance of Mr. A. Goel, then Principal Secretary BTC is exempted. And his personal appearance would no longer be required. By when you will file your affidavit?
Lordship, within 2 days.
Within 2 days.
If possible, today itself,
Okay,
because online filing some difficulties arises, so
okay.
Lordship may fix it at thereafter, Lordship.
I'll fix it on 21st of April,
Lordship. In the meantime, they will file their affidavit.
list on 21 for 2023. And in the meanwhile, the respondent numbers 3 to 7 will file their additional affidavit.
Much.
Item number 1, motion be
No.
Yes, Mr. Ahmed.
439 application lordship. Lordship earlier order is at page 34. Relevant portion starts from page 35. This bail application was rejected
this-
on,
Bangladesh.
my lord, yes.
Yes,
It was rejected on 29/9/2022.
yes.
And thereafter, lordship, 2 other persons were granted bail by the learned session judge. Your lordship will find at page 38. And page 40.
Okay, let us have it along with the record of, because the scanned copy is available in the other case.
And the case has not progressed yet, lordship. Still it is in appearance state.
We'll list it tomorrow.
My lord. Scan copy, my lord.
It's available in the earlier case. Otherwise, on 12th, we want to keep ourselves with less work, because I have to sign all the orders and release it on the same day. How many days you have been incarcerated?
For about 8 months, lordship.
8 months.
291 days. As on today.
Okay. List on 11/4/2023, along with records of BA 2287 of 2022, which were disposed of by order dated 29/9/2022. Okay,
Lordship will speak on 12. Tomorrow. Problem.
item number 2, motion.
This is AB, my lord, twice rejected earlier, but no new ground, my lord, 326 and 302, my lord.
May I please your lordship? My,
Yes.
my English senior is another, has another code, so please, my lord, give you some time.
okay. After some time.
P for admission.
May I please, Lord?
Yes.
Well, before Lordship for convention appointment, my lord, his father was, my lord, official assistant at a senior madrasa and
Just give me 2 minutes.
already earlier, but he came before his normal court, my honorable court passed an order in page 22. My lord.
Okay, who's appearing for state?
Page 24 is the communication also, my lord. The director Madras Education wrote a letter to the inspector to place the matter before DLC, my lord, in 2021, 11, my lord. As yet not placed. So my limited PR before Lordship, your Lordship will dispose of the matter directly to place the matter before DLC. only.
No, but you see this, your application was made when?
Well, pursuant to one of court's order, my lord, I submitted on your Lordship will file at page 23, my lord. This is the court's order, my lord. 23, last paragraph. In view of the above, and as agreed to the paid for the Rani Council for the parties, the respect of with a motion stage with a direction to the petitioner to file a fresh representation along with a copy of this order and also copy of the repetition before this respective authority within a period of 15 days from today. On receipt of such representation, the respective authority shall consider the such representation of the petitioner for his approval commission ground within a period of 4 months strictly in accordance with the provisions of law. Thereafter, he submitted it. Page 24, madam. This is the communication of the director of Madrasa Education from madam.
But Mr. Rahman,
My lord.
not only this court, but also the Supreme Court has said that the appointment for compassionate ground must be on the strength of the scheme itself.
Right.
Correct. Now the scheme says there is a limitation to the application being made. So notwithstanding that this court had earlier directed your application to be made, but we can't direct the appointment to be considered because of the fact that it would be not within the scheme.
But if you lordship dispose of representation directly to place the matter before DLC, if they reject it on that, then it is going on.
No, I understand. You see, always I have a question. And this question is based on event which happened in Rajasthan. In Rajasthan, there was a terminally ill minor boy who had cancer and was dying. He wrote to the chief minister that he wanted to be a police commissioner. And the state of Rajasthan appointed a minor boy as a police commissioner for the day. It's a fact. You search in your mobile, you'll get it. Police commissioner for a day in Rajasthan. So a minor boy became police commissioner for a day. Now the question is, somebody today applies before the court saying that in Rajasthan there was a man appointed as commissioner. So I have also submitted a representation. Please allow the state to dispose it off. My question is, can I send it? So even if there's a precedent in the country, and you'll find more examples of this sort. Minors were permitted to have PhD course being taken. They were exceptionally brilliant. One boy in mathematics in this country was permitted to pursue his PhD without having done his graduation. So these are exceptionally brilliant people for whom exceptions are carved out. But in this case, you'll have to explain to me that why beyond this scheme we can go. The Supreme Court says that the scheme of appointment must be within the four corners of the scheme. Now, if there is a limitation of 1 year to apply, how can we extend that time and ask the authorities to consider? That will be an uncompliable order because of the fact that the order which I will be passing would be contrary to the full bench decision. Achyut Ranjan Das. How can I, as a single judge, override the full bench decision of this court? Supreme Court says it will be indiscipline, judicial indiscipline. That is the word used.
Although I have mentioned here, my lord, initially this sister was applied. Subsequently, she has got married. Thereafter, brother applied, my lord.
It's okay, but
no
that is
fee
spent
paid here.
force. The court can't direct the state. The order of this court is not compliable. Yes, Mr. Thegya, you admit his prayer.
No, madam, because my lord, scheme said, my lord, that consideration within 2 years, my lord. If he's made it after 2 years, my lord, there is no requirement of the further consideration.
Mr. Rahman, I'd like to dismiss your matter. Mr. B. Rahman, then counsel for the petitioner. And Mr. P. Saikia, and government advocate appealing for
My lord, I am 1 and 5.
respondent numbers 1 and 5. For education, you are there, Mr.
3, 4, and 6.
U. Sharma, then standing counsel for elementary,
No, secondary, my lord.
secondary education department, appearing for respondent numbers
3, 4, and 6, man.
2 also,
Two also.
2, 3, 4, and 2, 3, 4, and 6. Next para. The case of the petitioner is that his father, while serving as office assistant at Singari, SINGARI, Senior Madrasa, under the jurisdiction of Inspector of Schools, Nagaon District Circle, Nagaon, died in harness on 19/12/2005. Full stop. Initially, the elder sister of the petitioner had applied for appointment on compassionate ground. But due to her marriage, her application was not considered. Full stop. Accordingly, the petitioner submitted an application. When did you submit your application?
The date of the earlier application is not here, my lord, but subsequent date of the subsequent application pursuant to court's order is 8/9/2020.
No, earlier application is when?
Earlier one date is there.
Not there.
Not there.
Okay. Apply for compassion ground. Full stop. However, the said prayer was not considered. Full stop. Thereafter, the petitioner had approached this court by filing a writ petition, which was registered as WPC 4038 of 2011. And this court, by an order dated 26/8/2011, while disposing of the writ petition at the motion stage, permitted the petitioner to file a fresh representation along with a copy of the said order, as well as a copy of the writ petition before the respondent authorities within 15 days. And it was provided that on receipt of such representation, the authorities would consider such representation for his appointment on compassionate ground within a period of 4 months, strictly in accordance with the notification, guidelines, etc. Full stop. Next, the learned counsel for the petitioner projects that to his information, the application made by the petitioner for appointment on compassionate ground was not placed before the DLC for consideration, and accordingly, the petitioner has approached this court again by filing this writ petition under Article 226 of the Constitution of India.
Page 24 is the communication. Page 24. This is the communication of Madrasa Director Madrasa Education, where reflected, my lord, the application of Baharul Islam dated 8/9/2011, pursuant to court's order.
And it's okay. I've said that you should not consider
Yes.
filing a writ petition under Article 226 of the Constitution of India, because thereby, whereby the petitioner has prayed for a direction upon the respondent authorities to place the matter before the district level committee and to consider his case for compassionate appointment. Next paragraph. The learned government advocate has opposed the prayer on the ground that it would not be in consonance with the office memorandum dated nine 1983, which was in no, the death was 2005. 2005, 83 was prevailing.
Prevailing. 2009, 7
Okay.
days of notification.
Okay.
Subsequent to 2015.
Where is the time limit given here? In this OM of 9 September 83, there's no
No, my lord, there is no time bar. in
No time bar,
time
no,
bar.
no time.
Subsequently, my lord, in Kodiram Nasan Ochut Ranjan, then time bar was given. Very soon I will go.
Okay. I got that. I said that it is submitted that pursuant to decision of this court in Achut Ranjan Das, you just get that citation and Fazirul Nasa. This court, the full bench of this court had provided a limitation for consideration of the period for appointment on compassionate ground. And it's submitted that at present, as per the office memorandum for compassionate appointment in force, the time limit is prescribed is
2 years, my lord.
2 years from the date of death of the concerned employee. Next paragraph.
Application have to submit within 1 year, my lord. Application have to submit within 1 year, my lord.
Yeah, just correct that. Application must be submitted within a period of 1 year. And the period would be considered for a period of 2 years.
2 years.
in the case of Central Bank of India versus Nitin, within bracket 2022, 0 Supreme within bracket SC, bracket was 1278. Comma, civil appeal number 5111, with 2022 decided on 3/8/2022. Comma, amongst others, comma, it was observed that compassionate employment cannot be made in the absence of rules or regulations issued by the government or a public authority. So the request is to be considered strictly in accordance with the governing scheme, and no discretion as such is left with any authority to make compassionate appointment divorce the scheme. And that an application for compassionate appointment must be preferred without undue delay and has to be considered within a reasonable period of time. Next one. In view of the settled position that the compassionate appointment is an exception to the rule of equality, which enables the dependent family members of a deceased employee to tide over the immediate crisis caused by the death of the breadwinner. And therefore, consideration for compassionate appointment must be strictly in accordance with the prevailing rules for compassionate appointment applicable to the deceased employee. Next, in this case, the full bench of this court has held that if the applications of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such applications, all such applications will require no further consideration and must be understood to have spent their force. Next paragraph. In the present case in hand, the predecessor in interest of the petitioner expired in the year 2005, and therefore vacancy, if any of that period, cannot be considered for being filled up with by way of compassionate appointment. Under the erstwhile office memorandum, as the parameters have changed by now, and at present the by now next paragraph. In view of above, the court finds that notwithstanding that this court by order dated 26/8/2011, passed in WPC 4038 of 2011, had directed the application, had allowed the petitioner to file a fresh representation for appointment on compassionate ground. First of all, from the said date, more than 12 years has gone by. And moreover, in view of the fact that the consideration cannot be made in view of the decision of this court in Achyut Ranjan Das in bracket Supra, the court finds no merit in this petition and therefore this petition is dismissed.
So, item number two.
It's a old pending case.
Yes.
Number two.
No, this bail matter. Bail matter is important.
May I please your lordship? My lord, this third application, my lord.
Just a moment. This Achyut Ranjan Das is 2006 4 GLT 674. Achyut Ranjan Das and others versus State of Assam and others. Yes,
May I please your lordship? My lord, this is third application, my lord, earlier rejected twice by your lordship, my lord. I have annexed both the orders, my lord. It's not,
what are the new grounds to entertain this?
my lord, can you see, my lord? In the meantime, my lord, some more of the persons have been arrested, my lord. And my lord, your lordship, may kindly see, my lord. Earlier, prior to rejection of this, their petitioner's bail application, my lord. 3 persons were arrested, my lord. I have annexed those forwarding report also, my lord. In the forwarding report, my lord, the police said, my lord, they were arrested only on suspect, my lord. I have annexed the forwarding report also, my lord. Your lordship, may kindly have a look, my lord, page 17, my lord. In the ground of arrestment, the police, my lord, searching all the neighbors, my lord, and my lord, the immediate neighbors, my lord, and the petitioners, my lord, before your lordship here, my lord. They are the cousin, brother, sister of the my lord, prime accused, my lord, who has inflicted the injury, my lord. It is, my lord, if your lordship, my lord, once, my lord, go to the FIR, my lord, I have, my lord, your lordship, page 9, my lord, your lordship, my lord, once, my lord. This, my lord, the FIR, page number 9, my lord, these persons, my lord, accused persons, my lord, they are the, my lord, son, daughter, and wife of my lord, Ahad Ali, my lord. And in the page 10, my lord, these are,
You see, in this case,
my lord,
notwithstanding whatever is available, but from the case diary, we found that
my lord,
at page 22, it is reflected.
yes, my lord,
The petitioner number 1 and 2, who are female members,
my lord,
they caught hold of the man. And then petitioner number 3 handed over a dagger to Akhtar. And this Akhtar stabbed. So therefore, the entire family is implicated and the specific actions are attributed to them.
my lord.
So where is the new ground to reappreciate what you are saying?
So far as my lord,
And you see, the death was due to hemorrhage and shock as a result of injuries sustained all over the body as described.
my lord,
So therefore, 2 female members were holding this victim, and he was repeatedly being stabbed. After arrest, we have no problem with releasing people,
my lord, it's,
but this is pre-arrest bail application. No,
at this stage, my lord. At this stage, my lord, I am paying, my lord, because my it is rejected, last rejection is.
no, that is okay, but you have to now show a new ground. If the ground is not available, then we have to reject it.
Ground, my lord, the investigation has, my lord, sufficiently progressed, my lord, in the meantime, but your last rejection is.
Without your arrest, how can it proceed?
So some more persons arrested, my lord, as per instruction of me, my lord.
in this connection with this case, my lord. So there is statement also there in the case diary, my lord. So with your lordship, I'm not praying for any other order, only for up-to-date case diary, my lord. If your lordship once again, my lord, verify, my lord, if your lordship, my lord, consider it, my lord. Only for case diary, my lord. Some more persons have been arrested, my lord, for instruction, my lord. Instead of producing the case diary, the learned MP shall produce the scanned copy of the relevant materials against the petitioners and of the status report of investigation insofar as the petitioners, namely, there are 1, 2, 3, 4 petitioners. 1, 2, 3, 4 are concerned. Based on 26/4/2023. Of last month.
Or
Yes, Mr. Goswami.
That's it. In the old pending case, Lordship,
Yes,
petitioner was originally terminated from service, and thereafter, Lordship, termination has been set aside by this honorable court by order dated Lordship will find at case 17/2008. And petitioner, the authority was directed to pay all the constitutional benefit. Thereafter, Lordship, petitioner has been reinstated in service. And the Lordship, the salary portion, the area salary has been also calculated. Lordship will find
Okay.
at page 23. Is a calculation.
What is your stand? We'll ask your officers to be present.
Well, actually, my lord, I need some time on 30 March, my lord. I have received a communication from the department, my lord. They have asked for a fresh petition of the case, my lord. That is
That
why
is why-
they could not provide the instruction, my lord. So, my lord, some time will be granted, my lord.
Lordship,
I will
law
release.
pending
You
case.
you see, so 2016,
Well-
he's demanding 6 lakh some odd rupees. After reinstatement, you have not paid him.
No. They have paid, Lordship.
Okay,
They
then
have paid, Lordship. Kindly see the calculation portion at page 25,
25.
Lordship. Cases like,
You are entitled to 75,000 more,
oh, Lordship.
75,000 more.
Look, because Lordship, tax component has been deducted the calculation sheet. Again, they have deducted the calculation sheet.
Okay, 24.
Page 25, the calculation, Lordship. Page 25, Lordship. Total entitlement is page 25.
Yes.
Total entitlement was 7,57,705. Thereafter, Lordship, they have deducted the tax component. Tax component is, Lordship, the reduction in the. After deduction, Lordship, total entitlement is 6,86,607. Now, Lordship, I have been paid. Lordship will find page 27. $6,09,485
Oh, so you're trying to say it is deducted twice.
twice.
Okay.
Lordship will find the tax already deduction in the page number. Lordship will find page 23.
Okay, I get it. Mr. S.K. Goswami, and counsel for the petitioner. So it is submitted that the service of the petitioner was terminated, which was challenged before this court. And this court had set aside the order of termination by order dated 1/7/2008, passed in WBC 2453 of 2007. And it was directed that the petitioner be reinstated with consequential benefits. Full stop. Review petition preferred by the state was dismissed. And in connection with contempt petition, this court had directed the order to be complied with within 3 months. First of, however, after some delay by an order dated 18/9/2012, the area salary of the petitioner was sanctioned at rupees 6,86,607. By referring to the calculation sheet provided by the head teacher / secretary, 706 number, number 2, Nathkuchi, NATHKUCHI LP School, provided the petitioner with a calculation sheet
And according to the has been sanctioned.
just a moment. Within bracket page 23 to 25, showing that the area salary of the petitioner was rupees 7,57,705, and after deduction of professional tax,
GIS contribution and GPF.
GIS contribution and GPF, the petitioner was entitled to a net amount of rupees 6,86,607. By referring to the amount credited to his savings bank account, the learned counsel of the petitioner is referred to the passbook entry disclosing that a sum of rupees 6,09,485 was credited to his account on 3/3/2015. Accordingly, it is submitted that a further amount has been deducted on account of professional tax and other recoveries, which could not have been done as the professional tax and other deductions were also already made as per the calculation sheet at page 25 of the rate petition.
And amount also sanctioned same amount, page 18, 6,86,000.
The sanction I have already stated.
What's it?
Next paragraph. The learned study council for the elementary education department raised for some more time to obtain instructions. Next paragraph. Having noted that that notice was issued by order dated 24/8/2016. Until date, the respondents in the elementary education department have as well as the finance department have not responded. One last opportunity is granted to the elementary education department and finance department to file their counter affidavit within 15 days from today, i.e. by 25/4/2023. The respondents in the elementary education department and finance department shall take notice that in the event no affidavit is filed within the time allowed, the court would invoke the doctrine of non-traverse. And it will be deemed that the respondents have admitted the claim of the petitioner. And accordingly, the writ petition shall be disposed of on the next date. And applying such doctrine. Next para, the respondents in the elementary education department and finance department are also put to notice that as the respondent authorities in the, the Director of Elementary Education, Assam, had issued a sanction order on 23/2014. The said authorities shall also be liable to pay interest at the rate of 9% on the balance amount wrongly deducted towards professional tax and other components like GIF,
Yes, GPF.
GPF, etc. Next para. If the respondents desire to escape payment of interest, it will be open to the authorities to consider release of the balance amount to the petitioner prior to the next date of listing. Mr. H. Aliya for respondent of 5.
Lordship, if I can make a submission, Lordship, regarding area salary, my lords, the budget is already with the administrative department.
No, I know, you see, but ultimately when they don't pay,
Lordship.
it is the finance department of the state who benefits,
Yes, Lord.
correct?
Yes, Lordship, but without the proposal, finance department.
No, I understand. That's why I said, you have 15 days time to file an affidavit. Within that day, if you can pay it to him, you save the interest.
Lordship.
If you don't pay within that 15 days, don't file a response, then we'll have to adjudicate. Correct. So some interest to the petitioner on adjudication.
Budget of the administrative government. Education.
Whatever be,
Lordship.
whatever be. But you see, for 70,000, if Mr. Goswami has to appear for last 5 years, 7 years, I think what you call interest is due. The standing council for the elementary education department and finance department shall send a downloaded copy of this audit to the authorities for compliance.
God bless.
Mr. Goswami, if you can spare him a copy, he does not have a copy.
Lordship, I'll give you. I have, are they acknowledgement also receiving copy also?
It's
Yes,
okay,
sir.
but
I will give those.
after 7 years, they might have missed.
I will give those.
Right.
And for the-
List on 28. 28/4. Yes,
Lordship, in this matter, education has filed a affidavit.
yes,
Lordship, I need to get some instruction.
okay.
Kindly, matter may be.
Both sides are represented. Mr. U. Sharma, and standing also for the secondary education department, has submitted that. And
No, my lord, she on her, my lord. I am.
no, you have filed an affidavit, otherwise
Yes,
you will impose 25,000 cost.
No.
That's
In
right.
last order, U. Sharma representing the petitioner and U. Sharma.
U. Sharma also for him.
Yes.
So both are U. Sharmas.
No,
No, P. Sharma.
P. Sharma, okay.
C. Sharma.
C. Sharma, okay. It's okay. U. Sharma, the standing counsel for the secondary education department, has submitted that the secondary education department has filed an affidavit. Next para. Mr. C. Sharma, and counsel for the petitioner, praised for and is granted 2 weeks time to respond. Next para, list after 3 weeks.
My lord, petitioner is also get the appointment in 2017, madam.
Oh, is it?
Yes.
Okay.
7.
Yes, sir.
It's regarding non-payment of the admissible amount of the
Yes,
medical.
within how much time you'll pay?
Chief, I have given this thing, my lord, instruction which you received from the department.
What does it say?
Chief, it says that with this thing, my lord, the for doing the needful, the petitioner shall approach his parents' department for taking forward the process, and once it is done, the authorities need in the parent department in the elementary.
No, why,
division
why,
shall do
why
the
should
needful.
you, why should we go again?
No, no, my lord, what
2017?
has happened is the certificate, that is the referral medical certificate, has to be issued. He has not produced that.
No, then we'll direct the authorities to be present here. You see, he is waiting in this court since 2017. Why should we send back him to the direct?
No, my lord, this certificate which is there, my lord, referral medical certificate, that will be required to process it. For that, we are waiting, my lord. He has to produce, the petitioner has to produce. That is not, my lord, there is an order also, my lord.
We'll have to produce from where?
My lord, he has to produce from the, this thing, my lord, from the concerned, my lord, department, my lord. He
So
has to
which-
go to the, he has to approach the DEO also, and also he has to approach the concerned health department.
So both of them are here, parties here.
There might be, he should approach, he is not approached.
We'll ask them to be present
My lord, I
here.
have given a copy.
We'll ask them to be present here.
There is an order of a different court also, where, my lord, similar, my lord, direction was given, where, my lord, a
you see-
representation was asked to be given,
Mr. Furkan,
my lord.
please be practical. You see, he is waiting in this court for 6 years.
My lord.
Nobody responds. We send back him to the authorities. They will again make him run from pillar to post. And he'll come back to the court again and we'll ask him to wait for 6 years more.
My lord, here, my lord, a similar order has been given, my lord.
No. This is not a precedent.
Can you see it once, my lord?
This is not a precedent. He is waiting in this court for 6 years. If the authorities don't find a response, we'll ask these people to be here.
My lord, he has to produce the certificate, my lord. He is the, my lord, the health.
No, both of, you see, we'll make your officers, we'll give them a table. We'll make them sit here and work.
Lordship, there is a admissibility report, Lordship, at page 32. 2011. It's a different matter, I guess.
Yes, 1,90,000.
Yes, Lordship, at page 32, it is around 2,86,023 rupees
No,
was.
for that 74,000 you rejected. So
Yes,
190 at least that should be paid to him.
Yes, Lordship, it will be the parent department, Lordship. Will be.
But he has to give the thing, no? He doesn't have it. So,
Lordship, that instruction.
Mr. Furkan,
my lord,
please make me understand.
my lord.
You see, you have already rejected an amount. Correct?
My lord.
Now, after rejection, no, let me ask you in a different way, which you'll understand. You are the counsel for the writ petitioner.
Hello.
Correct? You make 2 prayers in the writ petition. I allow 1 prayer and don't pass an order in respect of 2nd prayer. So we follow a principle that the prayer made and not allowed would be deemed to be rejected. Correct? Now for that 1 prayer, if you go for enforcement, will you like it that the authorities will say, no, for the second you bring an order from the High Court, then only we'll process.
No, my lord.
No, so you see, when I make you a petitioner, then you understand. Now here is a case where 190 after rejecting of 70,000 was accepted by the authorities. Now, why will you go and find out any other document and again give it to you? It is your department who is saying that 190 we are sanctioning. So what is stopping them from making payment?
My lord, I'll leave it to your lordship.
At this 9% interest, and the officers who delay beyond 2 months will pay interest from their own pocket.
I'll leave it to your lordship.
Huh?
If not payment.
If not paid.
No, Mr. Dhar would not be here after payment.
After 2 months, my lord.
I call him, what you call, jokingly, I call him a wholesale lawyer. He's not a retail lawyer. So he'll not be here. When his client receives payment, he'll not be here. Mr. Dhar knows value of time. Oh, so these authorities have rejected without referral document. That is not acceptable. Then how did page 32 happen?
She will give a time frame, Manoj, they'll look into it, Manoj. 2 months, Manoj.
Hmm.
2 months, Manoj.
The authorities will move the any other authority they want. The petitioner will not run here and there.
Manoj
Yes.
will,
He has approached this court, that is good enough.
Manoj.
But Mr. R. Dhar, learned counsel for the petitioner, also heard Mr. A. Fukan, learned standing counsel for the Elementary Education Department, representing respondent numbers
1 and 3, Manoj.
1 and 3,
6 and 6, Manoj.
1, 3, and 6, and Mr. D. Upamanyan, learned standing counsel for the Health Department,
2, 4 and 5.
representing respondent numbers 2, 4, and 5. Next paragraph. This appears to be a classic case where the respondent authorities have by inaction on their part, jointly and severally have refrained from making payment of admissible amount of rupees 1,90,376 towards medical reimbursement bills. Next paragraph. The petitioner, the next paragraph, the case of the petitioner is that he had to incur an expenditure of about rupees 3,00,100 towards treatment of his son. Who was initially admitted in Silchar Medical College and Hospital. Thereafter, he was shifted for treatment to Guwahati Medical College and Hospital. And on the advice of the then professor of the Guwahati Medical College who was attending the petitioner, the petitioner had to shift his son on emergency to the Asian Institute of Gastroenterology, Hyderabad, for treatment. Full stop. The petitioner had submitted his medical bills of the vouchers along with a forwarding letter dated 31/12/2009 to the
Block elementary.
Block Elementary Education Officer, Katigoda, full stop. As the payment was not made, the petitioner was compelled to approach this court by filing a writ petition, which was registered as WPC 1907 of 2012. And this court, by order dated 12/5/2015, disposed of the writ petition with a direction to the petitioner to submit a fresh medical reimbursement bill along with photocopies of medical bills of the vouchers to the respondent number 3 to the Director of Elementary Education within Assam, within bracket respondent number 3, with a direction that he would forward the same to the Commissioner Secretary to the Government of Assam within bracket respondent number 1. Government of Assam, or Department of Education within bracket elementary within bracket respondent number 1. Full stop. The respondent number 1 was also directed to comply with the provisions of Rule 6 within bracket C, small c, of what is this 2008 rules? What is the name of the rule?
Medical attendance rules.
Medical
Attendance.
attendance rules, 2008. Full stop. Next paragraph. Accordingly, on 25/2015, the petitioner has submitted his representation before the Block Elementary Education Officer, Katigora, covered name is Assam Medical Attendance Rules. As the payment was not released, the petitioner has approached this court again by filing this writ petition under Article 226 of the Constitution of India with a prayer for a direction to the respondent authorities to release the admissible amount as per order number 3177 dated 10/3/2016 passed by the chairman, district M full stop, A full stop, A full stop, B full stop, and Joint Director of Health Services, Kachar Future. Within bracket, annexure Roman 6, page 32. Next paragraph. Although notice of motion was issued by order dated 2/8/2017. The respondents have not filed their affidavit in opposition. Next paragraph. The Learners Standing Council for the Elementary Education Department has produced a copy of letter number so and so dated 18/3/2023 from the Director of Elementary Education Assam to the Senior Standing Council for the Elementary Education Department. So the contents of the said letter is quoted below. Next paragraph. It is noted that Mr. Dhar, what has happened after this order dated 28/11/2018? Here the court had given you a direction. Mr. Fukun was otherwise right.
Yes, sir. Thereafter, Lordship, by information we have submitted.
Where
But
is that?
since we have lost contact with him, however, we have written a letter to the petitioner regarding this.
He's not submitted. But they have not submitted anything.
No, you see, we will have to condone it. You see, the reason is in 2017, when the petitioner approached this court, he was 62 years. So now, after 7 years, he will be 69. 2018, he is not in contact
Yes.
with the petitioner. So these officers will have to treat this as the referral certificate. It is issued by a joint director of health service. After that, what more it is required? Yes, Parag. The court takes notice of the fact that on 24/4/2017, when the petitioner had sworn the affidavit appended to this writ petition, he was 62 years of age. And by now, if he's alive, he would be about 69 years of age. Full stop. Considering the fact that an authority none other than the Joint Director of Health Service, Kachar Silchar, who is also the chairman, District MRAB. What is full name of MRAB? Medical Referral? Okay, let it be. MRAB had passed an order bearing number 3177 dated 10/3/2016.
Medical Referral Advisory Board.
Okay. Medical Referral Advisory Board. Okay. Medical Referral Advisory Board had considered the bill submitted for rupees 2,86,083 and had deducted non-admissible amount of rupees 74,570 and assessed the admissible amount of medical reimbursement to an extent of rupees 1,90,376. It would be a gross injustice to make the petitioner run from pillar to post and obtain a fresh certificate from the concerned authorities, i.e. the Referral Medical Board, for issuance of a fresh medical referral certificate. Full stop. Chairman, District Medical Referral Advisory Board and Joint Director of Health Services, Kachar Silchar, comma, the said authority without existence of admissibility report could not have found the admissible amount to be rupees 1,90,376. So moreover, the court also finds that in the said order number 3177 dated 10/3/2016, comma, the Joint Director of Health Service, Kachar, come Chairman, District MRAB, has also made a nota bene, NOTABENE, within bracket, NB for short, mentioning therein that, inverted comma start, the admissibility report has been issued as per CGHS rate, inverted comma closed. Under such circumstances, comma, to make a senior citizen run from pillar to post to get a fresh medical referral certificate after 11 years of first approaching this court by filing WPC 1907 of 2012. Would be contrary to the directions contained in order dated 12/5/2015, passed in WPC 1907 of 2012. Next, accordingly, as the authorities would be issuing the medical referral certificate are under the control of the Commissioner and Secretary to the Government of Assam, Department of Health, within bracket respond number 2, and Director of Health Services, Assam, within bracket respond number 4, and Joint Director of Health Services, Kachar Silchar, within bracket respond number 5, comma, it would be appropriate to issue a direction upon the said 3 authorities to either rely on the order number 3177 dated 10/3/2016 within bracket Annexure 6, Roman 6, issued by the Chairman, District MRAB, and Joint Director of Health Services, Kachar Silchar, within bracket respond number 5, or to issue direction upon their own authorities to prepare and send them a fresh medical referral certificate in such form as may be required. Without requiring the petitioner to move from pillar to post for obtaining such certificate. Full stop. Next, in any event, as there is already a sanction order number 3177 of dated 10/3/2006, where admissible amount to the petitioner is assessed at rupees 1,90,376, the respondents, all the respondents jointly and severally are directed to ensure that the payment of such amount be released to the petitioner within a period of 60 days from the date of the order, failing which the amount shall carry an interest of 9% per annum. Full stop. The state would have liberty to realize the interest from any of their officers of the staff who are found responsible for causing delay in making such payment to the petitioner. Full stop. The learned counsel for the petitioner shall serve a certificate copy of this order to the District Elementary Education Officer, Kachar Silchar, and provide the relevant bank account particulars to enable the authorities to wire transfer the amount to the account of the petitioner.
Just one thing, can we add, can it be 90 days instead of 60? It'd be better for us because of
Okay,
the
make it 90 days. Okay,
90 days will be inappropriate.
okay, accepted. Next, by the instruction produced by the learned standing counsel for Elementary Education Department is retained on the call. Okay, that's reasonable. Mr. Dhar, but what would happen if if the petitioner is no more? Then what would happen?
I have information that he is alive till date,
Okay,
but his contact number has. Please.
okay.
We
Yes.
we have received a copy of the affidavit filed by respondent 4. And also I pray for some time to file a short reply. Mr. Desi Gogoi has also informed that he is having some difficulty today.
Just a moment. Respondent number 4.
Lots of.
It's not here. When did you file it?
We are not responding for loss. We have responded to loss.
Okay.
We have filed long back loss. In 21, we have filed loss. 17/3/21, we have filed.
So if you are saying you have received the copy,
We have received today in the morning.
Respondent number 4 loss.
respondent number 4 has already filed it wrong back 2018 they have filed.
We have responded to loss.
No. He says that he's received it today.
Today loss, he says the respondent 4. 4 is the principal of Zangra College. Whether you have received 4 or 2. 4.
We have already filed the reply also.
He says that 4 loss.
No, but 4 can't file it without the leave. We can't permit him to file a affidavit. Respondent 4 has already filed an affidavit. He did not seek any leave to file another affidavit. You have a copy of that?
It's with one of my colleagues also. So the learned counsel.
But you can't be briefless when you are appearing before the court. You are a young lawyer and you have chosen to appear before the court without your brief.
Apologies for that.
Okay, the learned counsel for the petitioner, your name?
Lordship,
P. Dole, learned counsel for the petitioner submits that he has been served with a copy of affidavit in opposition filed by respondent number 4. So the said affidavit is not here, not on record. Moreover, it appears that respondent number 3 and 4 have already filed their affidavit in opposition on 27/4/2018. And therefore the affidavit, if any, filed today would not be with the leave of this court, and therefore the acceptance of the said affidavit shall be subject to further orders that may be passed by this court. Yes,
Lordship, I'm appearing on behalf of UGC. Lordship, we receive our instruction and we need some time to file our affidavit. Immediately,
2017
after
matters.
invocation, Lordship, we will file.
2017, the UGC wakes up now. Miss, your name?
K. Borpujari.
K.
Borpujari.
Ms. K. Barpujai and counsel for the UGC submit that she has received instructions and would be filing an affidavit in opposition. Next paragraph. In this writ petition, notice was issued by order dated 11/12/2017. Hence, it is provided that if the affidavit in opposition is not filed by the UGC within 25/4/2023, the acceptance of such affidavit shall be subject to orders that may be passed by this court. Next one, on the prayer made by learned counsel for the petitioner. The petitioner is permitted to file the affidavit in reply, if any, for responding of against the affidavit filed by respondent 4 within 25/4/2023. List on 28/4/2023.
Interim may be extended now. Interim order dated 11/12/2017.
No, there's already an order that we don't need a fresh order. Status quo, we maintain this. But this respondent of force affidavit will be subject to orders which may be passed. It's just right, there's no representation for you are for 1 and 2.
I'm for 1 and 2.
1 and 2, and you are for 5. None appears on call for the other respondents. Just make that.
9.
Mr. K. Kugel for 1 and 2. Huh? Yes. Yes.
You application.
Before you begin, I'll just take a break and come back.
That will be page 45. May I read it slowly?
This is in which writ petition?
The earlier writ petition of Justice Amitabh Verma, it starts at page. It starts at page.
You are a party there?
Malada, the petitioners were party to that. Page 32 starts. And at page 45, my lord, that paragraph is there. First, therefore, the number of candidates figuring in the merit lists exceeds the number of posts. The impugned list cannot be constituted to be a final select list to be acted upon for the appointments therefrom, as amongst others, including the same for recruitment to the vacant post inter alia, the law of reservation would have to be applied.
Can you fix it on 27th April? Election petition.
My lord, 27th will be Thursday.
No. Because that day we have an election petition fixed. Second May?
Well, the 2nd May, I had another matter.
4th May?
4th May.
Mr. P.K. Roy, counsel for the review petitioner is present. As complied understanding counsel for the AAC. Place for adjournment.
Responded 2 to 5.
Respond number 2 to 5, place for adjournment. You're taking note of the fact that this review petition is pending since 19/5/2017. prayer for adjournment is reluctantly allowed. Next, it is made clear that on the next date of listing, prayer for adjournment shall not be considered. Next, as agreed to by all sides, list on 2/5/2023. 4/5/2023. Your books.
11. Number 11.
Yes.
Should the respondents notify affidavit?
In 2018 matter, they are not filing affidavits.
And I am calling some element.
You are ready with the hearing?
Yes, Lordship.
Okay. Yes.
Lordship, petitioners were the promotion matter, Lordship, the petitioners were to be appointed as headmaster. In schools under the South Salmara Mankachar subdivision in Dhuburi district. And as per the gradation list, they were the senior most. They were serving as headmaster in charge. The schools respectively.
What is the age of superannuation for a teacher?
Should,
Mr. Fugan, what is the age of superannuation of a teacher in this ME Madrasa, ME school?
60 men.
16. Okay. Yes. Mr. Fugan,
My lord,
the grievance of the petitioner is that you mechanically rejected it without any basis. The claim for being appointed as headmaster or head teacher of the ME madrasas or ME school.
any school. Otherwise, that my lord, that notification should be followed, my lord, for promotion.
Where is that notice? That's what the allegation is, that you did not follow it.
My lord, may
Which is the notification?
my lord said that
No, that notification for promotion.
Lordship, one thing, my lord, Lordship, just now I understand the petitioner might have been appointed, Your Lordship. We'll have to get that instruction, my lord. There is a chance, my lord. Can this be fixed immediately after vacation? I can get my instruction whether the petitioner has been appointed. Because then, my lord, the matter will become infructuous. That's what she told me now. Because if then the grievance won't be there.
She is not reliable because she told me that she is ready for hearing. To you, she gives another instructions. She's not reliable.
My lord will fix it immediately, my lord. I'll get my instruction. My lord.
Okay.
Otherwise, my lord, the 2010 thing has to be followed, which is that according to the seniority come merit, my lord.
Okay. Both sides are represented on the plan made by Mr. Fukan and Council for the Elementary Education Department. Matters stand adjourned today to enable him to obtain instructions. List after ensuing the vacation. Okay.
13,
My lord, item 13, my lord, Mr. R. Majumdar is appearing, your lordship. Can this matter be taken after some time? My lord, he's on legs in court number 5.
Okay.
14,
Yes, you have the payment status in this 14.
My lord,
In this item 14, you were to tell us the payment status.
Yes, my lord, although the proposals were sent, now, my lord, with the new financial year, we'll have to start over again. And perhaps by June, July, we may be able to do it. We are not denying the claim. Here, my lord, what is said is
38,000 only.
my lord, the proposal has to go to the finance and they have to sanction it before we can pay it, my lord. Because the question of a non-drawal of that amount comes in from the treasury office. I hold it here. Next, I- We can go to the mediation.
There is no representation from the petitioner. Mr. R. Majumdar and standing counsel for the second education department prays for some more time to obtain instructions as by submitting that in the as new financial year has set in, the process would have to be redone again. Next. Having noted that the petitioner has approached this court for claiming non-payment of various salary to the extent of rupees 38,080, the amount being a meager amount, the court is inclined to implead the Commissioner Secretary to the Government of Assam, Finance Department, and the Treasury what is the treasury officer? What is the nomenclature? Treasury officer?
The district, my lord.
Treasury officer, Tinsukia
Tinsukia.
Treasury. Tinsukia has respondent numbers. 6 and 7. The registry shall carry out the necessary correction in the cost title. The for finance will be there, Mr. Chadia is there.
Yes, ma'am. He's his present in court.
Okay, Mr. A. Chadia, standing counsel for the finance department shall accept notice on behalf of newly imputed respondent number 6 and 7. So the court master shall the EOJ section, the EOJ pending, civil pending shall provide a photocopy of the order passed today, as well as a photocopy of the writ petition to Mr. A. Chadia and standing counsel for the finance department. Next paragraph. The finance department shall in the meanwhile, obtain instructions as to steps taken from their end for release of the pending salary of the petitioner from 110/2000 to 28/2001. The amount is not 38,080. It would be area amounting to rupees 35,305. Make that correction. 35,305. Next paragraph. This after 2 weeks. Please tell Mr. Chadia to get a copy of this petition and from them.
I will do so.
You're for?
I'm for number 4, principal. Number 4.
Yes. What do you have to say? Did you send the proposal?
Already we have said all that. All the required documents were being sent forwarded.
You see, this secondary education department has filed an affidavit where the amount due is referred to as 28,080. Correct.
Unless given in words, my lord, subject to correction, my lord, it could be a typographical error.
No, 38,080. Sorry, 38,080.
Claim is of 35.
Claim is of 35.
35. And my lord, claiming that amount after a period of 3 years from the date on which it was due, we should have contested it even on that stage itself. Because the claim is for a period from
No, it is not his mistake. It is your own admission at paragraph 5.
That is what, my lord.
your paragraph 5 says that he gave it, but GPF was not there.
GPF was.
So those things are not fault of the petitioner.
But then, since we are admitting the entire process, Malad, only what is taking time is that little, the proposal was sent to the government, what I have seen from the letter, is that it was returned back to the Director of Secondary Education saying that you give us a non-royal certificate. During the last financial year, the non-royal certificate did not come in. It was not sanctioned. Therefore, this time, Malad, I'll make sure that
Okay,
all
let's
documents
just hang on
go
one thing.
together.
If the disbursement of the amount, meager amount of 38,080, which is mentioned in para 6 of the affidavit in opposition by the Secondary Education Department, has not been made only for production of non-dual certificate, the newly implemented respondent numbers 6 and 7 shall take all necessary steps as may be required for prompt issuance of non-dual certificate of arrears salary of the petitioner for the period from 1/10/2000 to 28/2/2001. This stop answering. Give a fixed date. 3/5/2023. It is before that, you're right. It is hoped that the respondents should settle the meager claim of the petitioner prior to next date of listing. List on 3/5.
My lord, the difficulty would be we don't have a budget head now. The financial year just gone. The budget will come sometime in June. We get our heads, then we get whatever. We'll have to put it up for the thing. The budget will come and then we can process the whole thing. Otherwise, we don't have a budget head where we can fit areas of this. In the last year, there
For
was
38,000, I don't think the department would need a budget.
my lord, financial matter, finance. We cannot make the proposal because if Lordship will see the repetition also.
No, that is why I
The
have
heads are
implemented.
given.
No, today that's what I have done. That's why I implemented finance today.
Yes.
And then I have also directed that they should do the needful for issuance of non-dual
We
certificate.
cannot send the proposal without that particular head, my lord. In the
No.
repetition also,
That is what I am saying.
the proposal has. to be-
Today direction has been issued to those two authorities
Yes.
to issue a non-dual certificate. Whether
And
he
they
asked it
issue
for
the
me.
trial certificate, but the proposal has to be freshly made. The proposal has to contain a head under which this amount will be drawn by the department. That head is given to us sometime in June. So instead of 3rd of May, Lordship, if Lordship keeps it sometime in the mid of June, I would have something at hand. Because this is what the department is going to tell me on 3rd of June, 3rd of May. We don't have a head. And therefore the proposal is deleted.
Okay, 14/6/2020.
My regards.
By which time the interdepartmental correspondence and all necessary formalities shall be
Yes.
done by both by the Secondary Education
Secondary
Department as well as Finance
My
Department.
regards.
16,
Obliged.
Herein, my lord, I challenges the impugn termination order. Yes, my lord, I have
Before my
sought for the school authority.
Before my learned friend submit my lord, this matter has come up after my lord, last listed in 2019 my lord. After my lord, this matter is listed to them, my lord. We have not filed affidavit my lord. I seek some time to file affidavit and my lord, the record will also be necessary my lord. So record may be called for.
No, why is there a record necessary? He's or maybe asking his pension,
Proportionate.
proportionate pension. That is what all he's asking. You don't want me to look at the record and find out what pension is due to him, make calculation. Mr. Das,
Yes, please.
you don't want me to make a calculation.
This one. Some time may be given, my lord, for filing affidavit.
They have already filed their affidavit. 4 and 5. 4 and 5 has filed.
Yes, proportionate pension, who will be there? To tell us.
AG.
Because Mr. Chaudhary, you have made two alternative prayers. If you claim one, then the other has to be rejected. So you first make an election. You are challenging the termination, or you are asking for that retirement dues, because if that both prayers can't stand together.
Yes, my lord, it is there, my lord. But the thing is that I am challenging the termination order only because, my lord, the termination order was issued on retrospective effect. From 2010. Yes, and the order was issued in the year 2017. Lord. And in the year 2019, my lord, I have already completed 10 years of regular service. Although total period is 21 years.
Where is the info letter?
My lord, last page of the repetition, that is at page 43, my lord. Only on the basis of resolution adopted by the governing body, they have terminated the service. Page 43.
But where is, if you have been terminated with that date, what is wrong committed?
Wrong means, my lord, without any show cause, without any initiating any DP.
No,
disciplinary
but you
proceeding.
stopped appearing you have stopped rendering
Before that,
service
my
in
lord, before that-
January 2009.
Yes, before that, I applied for VRS. They said, no, you are not eligible for VRS. Thereafter, time to time, I have visited the office.
No, but you have not rendered service. Once they have been able to demonstrate that since January 2009, you were not attending the college. The date of 2010, what is wrong in it?
Wrong in-
They also gave an advertisement in the newspaper asking you to return to
within 15
job,
days.
but you did not return. So why should you be not terminated from the earlier date?
Actually, my lord, from 2010, I was not well. And as such, I prefer VRS. Yes, they rejected my prayer because I was regularized only on 25/3/1998. In the meantime, my lord, I have completed 10 years of regular service. So, my lord, I pray here in this writ petition for proportionate pension. Nothing.
You joined when?
My lord, initially I was joined in on 23/10/1988. Thereafter, my service was confirmed on 25/3/1998.
1990.
My services were confirmed.
Where is that order?
My lord, annexure 3,
Page.
not sure. Page 20. My lord, type copy is 18. 18.
So this is 2002.
If Lordship may kindly come to the affidavit of their affidavit filed by the respondent number 4 and 5. That is at page 2, my lord, paragraph 3. Last 2 lines. Paragraph 3, lord. Page 2. Three and 4. Lordship.
No, but that won't entitle you to be considered as a regular employee unless there's an order passed by the Director of Higher Education. That was passed with effect from 31/5/2002. So that period of benefit of being a what you call a teacher under the grant and aid scheme won't entitle you to anything.
My lord, para 4, my lord. And his services confirmed by order that such and such passed by the director with effect of para 4, lord. Regular.
No, their affidavit means nothing. When you see page 18 you are showing me, it doesn't say from that from effect from earlier. That order is not there by the Director of Higher Education. Page 18.
Actually, my lord, page 20 is not very much clear. It is the original one in that case.
With immediate effect, my lord. Immediate effect is, my lord, is 31/5/2002.
31/5/2002. It can't
Yes.
be with a back effect. So once you have stopped rendering service, it won't be accounted under the what you call pensionable service.
My lord, only thing is that my only prayer now is that, my lord, although I have completed 10 years of service, so my lord,
It can't be from 2002 to 2009 you left. It is 7 years of service. You can't be entitled to pension. I think the pension is 10 years minimum.
yes.
If it is 10 years, then you don't get anything.
My lord, in their affidavit, they have stated, my lord, therefore, that with regard to the statements made in paragraph 3 and 4 of the repetition, I reiterated the statement made in paragraph 3 of the affidavit in opposition, the counter for short, and further stated that the repetitioner was regularized with effect from 25/3/1998.
For their affidavit, you can file
That
as
letter is not with me, my lord,
No,
and
no,
his
this-
services
you
confirmed by
see-
order dated.
no, that is okay. But for that, you'll have to file a civil suit against Dr. Nipen Goswami and get it from him. He writes in his personal capacity. It won't bind the government. The government order is at page 18. It is 2002. So from
Okay, so,
98.
my lord, then let them file their affidavit. Respondent,
No, it's not required. That's why you see,
because this is the
no,
calculation is mainly based on this.
that is why I started the hearing, because you see, whatever they say, but if it is, if your appointment order, it can't be read as 1998. The affidavit can't, even if their affidavit is there, in my order, I'll give you liberty to recover the amount from this Nipen Goswami.
Yes.
That 88 appointment letter, my lord, it is clearly written, it's as in purely temporary, my lord. The appointment letter issued by the college authority, my lord, in the year
No, that is
1988.
okay. I'm really not interested in these college orders because of the fact that when the Director Higher Education gives the effect from 2002.
Of the writ petition,
15.
page 15. Page
Yes.
15, This is an order, Your Lordship, issued by Director of Higher Education. The order states that as per resolution number so and so passed by the governing body of Jawaharlal Nehru College, the below named lecturer college employees has been granted approval for appointment on temporary basis. So the claim of the petitioner that he was in confirmed services from 1998 falls through, Your Lordship. That is my only submission. That is, Your Lordship.
You are right.
Yes,
You are right.
yes. Lordship. It's from 2002, the services have been confirmed. On prospective basis, Your Lordship. It's 299. Lordship is very correct. It doesn't fulfill the 10-year criteria.
Yes, Mr. Chaudhary.
Yes, my lord, NHS is clear, my lord. My lord, then my lord, let it come after, just after vacation, my lord. In the meantime, if any documents, I will find that, I will file my affidavit. Regarding only that portion, regarding regularization of this service.
Okay.
Or my lord,
On the prayer made by Mr. S. Chaudhary and counsel for the petitioner, the matter stands adjourned today. Mr. S. Das, the standing counsel for the Higher Education Department, as well as Mr. M. Sharma, the counsel for respondent number
4 and 5.
4 and 5. Have pointed out that the service of the petitioner was confirmed by order dated 31/5/2002. By the Director of Higher Education Assam, which cannot be given effective from a date prior to it. Next, be that as it may, matters in the job today, just after answering the vocation.
and in the meantime, my lord, if they will file in. Once to
Not
file in-
required. In fact, after this is not required.
17,
You may file it if you want. In the meanwhile, the respondents are the education, secondary education, higher education department is at liberty to file their affidavit in opposition. Yes.
My lord, in this case, records were called for, my lord.
Yes.
Records has been received, my lord, today morning only, my lord. Records with me, but I don't know that I couldn't go to the records properly, my lord.
Just give me that record for a moment.
Yes.
You've gone through it?
Not, probably, my lord.
You're listing it on 21-4. This going through the records will hardly take you 5 minutes.
My lord, can it be on 25, my lord, 21, 25 or 36? Not on 19, 20 or 21, my lord.
Okay. Both sides are represented. On the prayer made by Mr. S. Das, and the standing counsel for the higher education department. Matter stands adjourned today to enable him to go through the original records pertaining to inquiry and suspension of the petitioner. But Mr. Chaudhary, you take instructions because it appears that the petitioner participated in the inquiry proceedings.
Yes, my lord. Subsequently, he was removed, my lord.
No, but you see, we had called for the case records merely because of your assertion that there was no departmental proceeding initiated against him. It was ex parte.
My lord, before issuing suspension order, no notice was issued to him. Notice was issued only during departmental inquiry. He participated, my lord. But subsequently, what happened, my lord? He was removed from service. Your lordship may kindly see the allegations. Allegations are very, my lord. Your lordship may kindly see. Allegations are at page 23, my lord. The inquiry report, my lord. Your lordship may kindly see the allegations.
Yes, that I've seen.
Very
I've
enthusiastic and
I've gone through the file.
Yes, my lord.
I've gone through the official records, but you participated in the proceeding.
My lord, the punishment is disproportionate, my lord.
No, not with that. What is there on record? Not with what is there on the record.
Inquiry report also, it is, you are very non-cooperative. You did not obey the principle. All these types of allegations, my lord.
No, but the materials are there. That's what I'm asking you. You see, for a lecturer, I've been a student of college, correct? And we know that there are few respected lecturers and professors who's who are unable to deliver it to the students. You see, for a teacher, he may be very exceptional in academics, but to teach students is a different ballgame altogether. The students are totally dissatisfied with your teaching abilities.
And for some time, he was mentally ill, my lord. The medical certificate will maybe in the.
It appears so, but you see, if the teacher is not in his good state of mind,
Subsequently, he recovered, my lord. He had submitted his medical certificate also before the authority.
okay, let him go through it, but the report is not very impressive. He's asking for 26, make it 26.4.
Much of it.
13.
May I please, Your Lordship. Your Lordship, my senior Mr. Angora lacks in food number 20. Kindly pass over the matter for the time being.
Lord, Mr. B. Burwa, Vedanta was, Vedanta Kaushik was preparing the matter. He's in Hyderabad, my lord. He'll be here after the vacations. As of today, my lord, my voice is giving me some trouble. I'm having some difficulty in making submissions.
Okay, he has gone for some medical problem.
My
medical
lord, I think his brother needs some medical attention.
Let me adjourn it. Both sides are represented. We submitted that Mr. B. Kaushik, non-standing counsel for the secondary education department, who was to
Elementary.
argue, elementary education department was to argue the matter, is out of session due to some medical issues with his brother. Just
My lord,
accordingly,
I pray that matter be reflected in the order. It goes back to the department. In that part, my lord, that his brother's part, my lord, department, it goes to the department, these orders. That we just cut it. He's not here, some personal difficulty.
personal difficulties, is unable to appear and argue the matter today. Accordingly, matter stands adjourned today. List again on 26/4/2023.
Yes. He'll be here. Bless you.
20 for orders.
Number 20, my lord, I am told it has been complied with. 20, my lord, has been complied with, my lord.
So, my lord, I am for the petitioner, my lord. I have no such instructions, so some time may be given. I'll obtain.
Please, we have shown him the compliance order. He'd like to have some instructions.
Both sides are duly represented. Mr. R. Mazumdar, and counsel appearing for respondent number
My lord,
4.
I actually representing Mr. Chisti, my lord, who was required to take some instructions from the department. Although
Okay.
we do not appear for the respondents, they are no longer there. We can bring a pension.
Okay, now let's turn first for the secondary education department has submitted that the order of the court has been complied with. Next, Mr. M. Agarwal, counsel for the petitioner, pays for some time to obtain instructions. Next, matter stands adjourned today. List on 28/4/2023.
24. Instruction for blowing. मैं करने का मेरे को कुछ तो मारी इशू और कुछ चीजें कंप्लेंट है क्यों है ये डिस्पोजल
21
हमारे item number 21 to 24 Mr. N.J. Khatoni was required to he's on his legs in some other matter. Today I cannot take up the file, but I am actually having some problem on the throat. Immediately on the
Second half will be free.
At 2 PM, my lord,
I shall inform you. Second half.
Always.
25 and 26.
Yes,
Actually, this is regarding Assam universities and order of 2018. Everything has been now complied with just lordship in March. Only thing is some amount is yet to be released. This is the chart. Lordship. This is regarding pension and the
I've
financial
seen that.
benefit. And this court time and again said ultimately lordship, because of the lordship endeavor, they have released most of the person lordship. Without PPO now lordship pension has been released for the month of March. Without PPO, PPO has not been issued. And this amount is still not paid.
Okay. Mr. S.K. Goswami, then counsel for the petitioners, has submitted that although a part of area family pension has been released, but it does not constitute the entire payment. Correct?
Yes. I will send the copy of this list also to lordship, to Kyle lordship. He will take the instruction. Lordship may
Okay.
record.
You're for whom?
I'm on behalf of SCKL, sir.
Button up your coat.
Respondent number
Button up
4.
your coat. Button up your coat. Put button on your coat.
Put to.
Button it up. Mr. Goswami will give you a slip. You just get it confirmed that these payments are not yet made. Stop. In this regard, Mr. S.K. Goswami and counsel for the petitioner has submitted that the no, what is this?
Lordship, GPF contribution from own contribution petitioner has contributed. That should be released to the authority, or where the authority is own contribution. They have released 90% in some cases, and 2-3 cases they have not released 100%, and 10% is yet to be released.
Has prepared a chart to project that the employee's contribution has not been released. Stop. Let the chart be, copy of the chart be provided to the learned. Your name?
Meenakshi Dekha.
Ms. Meenakshi Dekha, learned counsel, appearing on behalf of Mr. S.C.K.R., counsel for the respondent. So as to enable him to obtain updated instructions. Yes.
Worship, court had sought for my intervention because money was not released, but few days back, Mr. Kayal informed me that it has been released for.
No, now he says that you see in few cases, there 10% is yet to be released. His contribution.
My contribution.
Okay.
I will
So,
take the instructions.
okay, so we exempt you from appearing.
Worship.
Next, as the learned counsel is appearing for the respondent, the personal appearance, the appearance by Mr. R.K.D. Chaudhary, learned Solicitor General of India, is exempted.
Worship deputy.
Oh, deputy.
Obliged.
Okay, list on 3/5/2023. You get the instructions by then. If payment is not made, your balance amount should be paid. So as to enable the learned counsel for the respondent to obtain instructions and to make an endeavor to release the pending dues of the petition.
May I plead lordship? Lordship, I am appearing on behalf of DCC Bhupan. He is absent because he is not well. Kindly pass over the matter.
Just a moment. What is the instructions?
My lord, in this matter, MJ Khatuniar will appear, my lord. His name is shown here, my lord.
Let Mr. Khatune come, will ask this. Be there at 2 o'clock. Yes, BTC matter. We'll take it up at 2 o'clock. BTC matter. SCBTC. Yes, Mr. Khatrunia.
21 to 24.
This is a review preferred by the state, my lord.
Yes.
Against the judgment and order dated, my lord. 16/6/2016. Well, the basic claim of the prisoner is that, my lord, they were appointed as assistant teachers in various LP school in the district of Karimganj during the year, my lord, 1995-96. And they were claiming that, my lord, their appointment was pursuant to some selection process, my lord, which was initiated in the year 91-92, my lord. So, my lord, they have received salary till 1997, my lord. Thereafter, they have not been paid. So then, my lord, they have approached this honorable court, my lord, and the honorable court directed to verify their claim, my lord, and their claim was subsequently rejected, my lord. Against that rejection order, my lord, they have filed the writ petition. And that petition was allowed by order dated 16/6/2016, my lord. Against that order, my lord, this present review petition has been preferred. So our basic ground is, my lord, during the pendency of this review petition, my lord, as my lord aware of this screening process, my lord, there was a screening process conducted by the government of Assam in the Elementary Education Department regarding ascertaining the genuineness of appointees appointed during the year 91 to 2001. And in that screening process, the review petitioners were participated in that screening process, and subsequently the cabinet has took a decision to accommodate those irregular teachers who were not recommended by the subdivisional selection committee during that period, but they were continuing, my lord.
Just tell me,
Yes, my lord.
this annexure 1, page 28.
Yes, my lord.
Is this the order under review? No,
Yes, my lord. Yes.
correct.
Yes, my lord. Correct.
Now, in this order,
Yes, my lord.
if you can. Come to page 42 first.
42, my lord.
Yes.
Yes.
Just because before the page 39,
Yes, my lord.
para 6,
Yes.
in the after about 10 lines, according to Mr. Saikia.
Yes. The
They
state
said-
consolidated statement, which had been verified and endorsed by various authorities in the district administration as well as the departmental authorities, clearly reflects the entire particulars relating to the appointment of the prisoner. In this respect, Mr. Saikia also fairly submits that, save and accept the petition number 2 in WPC number so and so, Srimati Madhumita Goswami, the name of all other petitioners figured in the said consolidated statement. Mr. Saikia submits that the said consolidated statement gives a clear picture as to the year of advertisement, the interview number of the candidates, the selection date, the serial number of the petitioner as appearing in the respective select list, as well as the appointment letters number and date.
Yes, now page 43, there's a reiteration of the same thing at page para 11, last 3-4 lines.
Yes, brother. Which has been verified and
Which is
endorsed.
Mr. Saikia submits that consolidated statement, which has been so and so. Correct.
Yes, brother.
Now, after that, in para 12, there's a 4th line, there's a reference to fait accompli. Correct.
Yes, brother.
Now, last line of para 12,
Yes.
this is not the stand taken by the state government that when paper so and so, in the fact that although petitioners have continued to serve, no step has been initiated by the state respondent for interfering or questioning the appointment orders. So as to, not any steps were taken, the matter was sent back to the government. Then para 13.
Yes, brother.
This last about 6-7 lines. In the case of Mamta Mohanty, Nazira so do not come to the aid of the respondent. So is not a case where the appointment has made a clear departure from the prescribed procedure. or based on some unforeseen hand, so and so. So after this finding, and in the next page again, para 14,
Yes,
middle, dated 7/8/2015, and about 6 lines from above, abundantly goes in favor of the petitioners. So in the selection made by the so and so, with all his records have been submitted to the government way back in 1998. So with this clear finding, where is the scope of review to be entertained?
But the subsequent development Malloy, here, they have been identified as illegal appointee Malloy by the screening committee. And cabinet took a decision to accommodate those persons Malloy, who were either illegal or irregular, but they are continuing in service.
You see, Mr. Earlier,
Yes, Malloy.
you see, the court gave a finding. So the scope of a subsequent, what you call screening committee, how will it take away this finding of the court? There can't be a screening committee sitting above the High Court judgment
No,
and then trying to find out.
Case is, Malloy, the screening committee was constituted during the pendency of this writ petition, Malloy. The writ petition was filed in the year 2007. The committee was constituted in the year 2012, Malloy. And accordingly, Malloy, list was prepared, I think, Malloy, in the year 2018. And cabinet took a decision in the year 2020. Thereafter, Malloy, they have been accommodated as tutor, and they have, some of them have already been accepted, Malloy. They have accepted their appointment, new appointment, Malloy.
Where is the list of those people whose appointments?
Yes, Malloy.
Because there is another aspect of what the statement you are making. You're aware of the nature of order past page 46.
Yes.
Now the salary is to be made. The payment is to be made.
Yes, Malloy.
And you see, I go by the principles of, I borrow the principles of CPC. You see, unless after the order of the court,
Yes.
there is no amicable, what you call, resolution between both of you, thereby taking, by which the petitioner, sorry, the respondent here,
Yes, Malloy.
relinquishes his right, which is available in the High Court judgment.
Yes, Malloy.
So insofar as that part of the judgment is concerned, you can't say that it has been wiped off just because he has accepted the appointment.
But in the appointment letter, Malloy, there's a clause, Malloy, that they will forgo the other earlier claim.
No, forgo means only that thing which he has agreed to forgo. The High Court order is, there's no decree which says that he is not relinquishing any part of the judgment in his favor. For that, you'll have to, you should have made a clause that you forgo the rights which are flowing from the judgment of the court.
That clause was not there because, Malloy, this is a, in particular, some cases, there are some order to pay the salary, Malloy.
High
But
Court orders, we can't
as a whole,
allow
my
it to
lord,
negate.
As a whole, Malloy, there are more than 7,000 such type of cases, Malloy.
But this will have to be carved out an exception. You'll have to, unless you satisfy the court that the parameters for relinquishment would be covered here. Because you see, a relinquishment has to be in accordance with law. Merely because the state imposes a condition that I'm paying you 1 rupee, you forgo 10 rupees. would it negate the judgment of this court?
But they themselves participate in the screening process, madam. And that screening process was initiated for the purpose of ascertainment of the genuineness of the appointment.
No, let me tell you,
Yes, madam.
I have a feeling that last year a boy got first class first in metric exam. If you make him appear in a screening test again, I don't know whether he'll still be first class first.
That is the but here, madam, the question is genuineness of appointment, madam. This is not a
No, but this is a finding of the court. Even if he is next found, that is he's a illegal teacher. How do you sustain this review? Because the parameters of review will be that number one, which is the first point, that there was any error apparent on the face of record.
yes, madam.
The second parameter also, you know,
Yes, madam.
it must be something which was available, but you could not produce before without due diligence. That is the second requirement. And third is any other reason. Any other reason also has been.
Here, madam, our contention is that, madam, though there was a screening process during the pendency of the retribution, that we could not got in record, madam. Had it been not to the record, madam, it had been different, madam.
Where is the screening committee report?
This report, madam, at the time of filing of the review petition, report was not prepared. Report was prepared subsequently in the year 20.
So therefore,
That-
therefore you see,
Yes, madam.
it can't be a document which was existing at the time when the matter was heard.
Document was not in existence during that time, madam, but the process
Then
was initiated.
Would it form a part of, would it be a reason for review?
Process was initiated and they have participated in the process, madam.
Mr. Khan, you have to show that exclusion. You see, just because this is the example I gave, it may be not an appropriate example, but still, a boy gets first class first in metric exam. Everyone tries to honor him by giving some, what you call, he is publicly felicitated. And then one reporter asks a question, yes, how much is 1 + 1? And this boy says 3. Now, will that be a ground to question his degree, the metric certificate he has got first class first?
No.
Just because he have made one mistake while answering a query of the journalist. You see, same thing applies here. You say that he subjected himself.
Yes.
Was he put to notice that it would take away his right, which is accrued under the judgment of this court? He was not put to notice.
No.
Otherwise, he would have not appeared in that screening committee. You are not. So you see, therefore, when a judgment
Judgment
of
was
the
delivered later on, madam. Because it was subjected to screening committee in the year 2012, madam. Once it was advertised, thereafter they applied for it, madam. And judgment was delivered in the year 2016.
No, but that could have been, you see, the department was aware of the litigation. It could have said that this overrides the litigation. No point subjecting one to a what you call the process of screening and still allow the writ petition to be proceeded with. Well, I'm trying to find out answer not by questioning you.
Yes, madam.
For the purpose of these issues. My question to you is on 3 parameters of review. Error apparent on the face of record. A matter which ought to have been but could not be produced despite due diligence, or any other reason. Any other reason has been defined.
Yes.
To say that it will be within the scope of A and B. See, I'm asking questions only on these parameters.
Yes.
Not for testing the, what you call, the wisdom of the authorities to do it. It is only limited to our own view. Then how can you satisfy the court?
Well, in this aspect, well, may pray for some time so that I can find it out whether review can be done in this case.
It was a pure question of law
Yes, madam. I understand, madam.
and you say adjournment is not difficult, but the problem is that you won't have an answer to that even after adjournment.
Yes. Still, my lord, I'll try my best, madam, if I can find out something.
Yes, Mr.
One more
Segia.
aspect, my lord, I would like to draw your lordship's attention that there are 3 writ petitions, my lord, disposed of together. They have preferred review, my lord, against 1 writ petition.
Oh,
Other 2 writ petitions, they have not preferred review, my lord.
oh. Okay. Okay, address me that on the next date.
There are 5 respondents in the writ petitions. Only 2 respondents has filed a review petition. The other respondents are also not party in their review petition.
You are not parties.
They are not parties.
Okay, where is that order? Petition.
Page 28, madam.
The cost settle here.
Only 2 respondents have filed a review petition, my lord, against the petitioners in one writ petition. The other respondents are not party in the review petition, my lord. Page 33, you know, come to page 33 of the review petition.
Just a moment. Mr. N.J. Khatania, counsel for the review petitioners. Praised for an adjournment to address this court on the scope and ambit of the review jurisdiction of the court. Next slide. Mr. Ayaz Sehgal and counsel for the private respondents. Respondents has submitted that the review petition would not be maintainable on 2 counts. Firstly, out of several respondents in the writ petition, five respondents in 3 writ petitions. The 3 writ petitions. The 3 writ petitions, the review has been preferred by respondent number 1 and 3. In the connected writ petition, and that 3 of the remaining respondents in the writ petition have not been arrayed as party respondents in this review petition. Full stop. Secondly, comma, it is submitted that although common judgment dated 16/6/2016 was passed in 3 connected writ petitions, being WPC, what are the numbers?
WPC 5032 of 2007, 5066 2007, and 5067 2007.
But this review petition has been filed only in one writ petition, i.e. in respect of
503.
WPC 5032 of 2007. Full stop. Next, one, learned counsel for the respondents shall urge this issue on the next date of hearing. Next for this Tom. Yes, when do you want, Mr. Khatania?
My lord. On 27 or 28, my lord.
Okay, 28/4/2023.
Last month.
But this
Yes.
order has been complied with. I have the compliance order. Madam. May pray for some time. I will produce. Madam.
Okay, 27 order has been complied with. Okay, just give a copy to her,
Yes, yes, madam.
but I'll adjourn it to enable her to obtain instructions.
Yes, madam.
Uh,
Right now, I will
Okay.
give you a copy, madam.
Both sides are duly represented. Mr. N.J. Khatania, learned counsel for the respondents, has submitted that the order of the court has been complied with. Next, let a copy of the order be provided to Ms.
D Devi, Deepshikha Devi.
Learned counsel for the petitioners, so as to enable her to obtain instructions. List after 2 weeks,
My lord.
just say list after vacation.
Available.
28.
Yes, but the last occasion, my lord, it was invited to serve copy to the Standing Council of BTC, my lord. I have already supplied copy to Mr. B. Chaudhary. He was supposed to file affidavit for instruction. This order is receivable.
Order of the court, where is it? Page?
Page 12, man. Authority person you will find page 14, para 3, from onwards para 3. And para 4, minute, the writ petition was allowed. And the order of permission was set aside. And it was consequential steps were directed to be taken by the responding authorities for reinstatement of the petition.
The order in contempt is this order at page 12, right?
Yes, madam. Page 12 to 15, madam. Yes, will find. And thereafter, my lord, earlier contempt petition was closed by order dated 19, and liberty was granted to file a fresh after filing representation to the BTC authority, madam. And by the Annexure 4, Annexure 3, page 18 is the earlier order dated 17/12/18, passed by this honorable court.
No, but Mr. Nath, that is why I'm taking so much of time. I fail to understand. You see, this order in the writ petition
Yes,
against which you are alleging contempt was passed on 23/4/2015.
yes, ma'am.
This contempt petition is filed in 2019.
Yes, ma'am. Prior to that, my lordship will find page 18. Page 18, earlier contempt was filed in
No,
2016.
other contempt was closed
Yes, ma'am.
with liberty to you to approach the court if so advised. Approach means does not mean you are given liberty to file a contempt petition again. Because contempt petition section 20 says limitation is 1 year. Even by the order of the court, the period of limitation would not be extendable.
The lordship may peruse page 20, page 20.
Yes, 20 says
Because-
director BTC has neither been controverted nor by filing affidavit appears to address the issue. Therefore, the review, this contempt petition is closed. Liberty is granted to approach the court again. Approach the court again does not mean contempt. Contempt, Mr. Nath, under section 20, there is a limitation of 1 year. Contempt would not be maintainable. I'll have to dismiss your contempt petition.
And it was also, my lord, mentioned that director of BTC filed affidavit taken that the authority of the BTC has not received any representation from the petitioner, madam. And accordingly, the petitioner has filed the representation.
So that representation was filed in 2019, 8/4/2019,
Yes, madam.
correct?
Yes, madam. After the order of this, madam. Order was of 2018, 17/12/2018.
So 19, you see, just see section 20 and tell me how the,
No, that is clear, madam. That is clear, madam. That is a bar, but the cause of action, the lordship will find since earlier contract was closed, liberty was granted.
liberty was granted to approach the court again, not for purpose of contempt. Contempt, I can't extend my jurisdiction.
So it was also in confusion that whether a fresh read, it will be amounting to res judicata because there is a clear judgment on this point, madam.
No, for that you have this liberty to approach the court again.
So I leave upon your lordship, my lord, because it is not clear that approach, it means that, my lord, I have to file contempt or writ petition, fresh writ petition.
Because you see, BTC was not a party there in the earlier writ petition.
Yes, my lord, he was made party. Subsequently, he was implemented, madam.
Where?
Implemented, my lord. Your
Where?
lordship, writ petition, your lordship will find.
Page 12 doesn't say the BTC.
But in the writ petition, there was order, he was implemented, my lord. It was
Mr. Nath, they could not have-
para three, my lord, in the judgment 14, it mentioned, although in the post title, it is not reflected that it is the BTC authority, my lord, BSc authority in the schools located in the BSc area. This court is also held that the state government was not competent to decide on the validity of the appointment.
No, no, no.
That's also,
You relied on a batch of writ petition where BTC was a party.
yes, ma'am.
And this court takes that into consideration, 579 of 2007, and questions the order. But your BTC was never a party. So in a writ petition of 2007, where BTC is not a party, your contempt against BTC merely by giving a representation of 8/4/2019 would not be maintainable. Section 20 creates a bar, a specific bar. But Mr. S. Not level counsel for the petitioner. And Mr. R.K. Musari, level counsel for the respondent. By filing this contempt petition, the petitioner has alleged willful disobedience of order dated 23/4/2015, passed in WTC 3625 of 2007. Next one. On a query of the court as regards limitation in initiating action for contempt as prescribed under section 20 of the Contempt of Courts Act, 1971, the learned counsel for the petitioner has submitted that as the order of the court was not complied with, the petitioner had approached this court on a previous occasion by filing a contempt petition which was registered as Cont case within bracket C 260 of 2016. And this court, while closing the contempt petition, and it is submitted that by this court, by closing the contempt petition, granted liberty to the petitioner to approach the court again, if so advised. So the operative part of the order dated 17/12/2018, passed in Cont case 260 of 2016, is extracted below. Page 1920. Footnote. Next, accordingly, the learned counsel for the petitioner has submitted that after passing of the order dated 17/12/2018, the petitioner had submitted a representation dated 8/4/2019 before the Director of Education within bracket, BTC, Kokrajhar, for considering the order dated 23/4/2015 passed in by this court in WBC 3625 of 2007 and reinstated the petitioner in service. And as the said representation was not acted upon, this present contempt petition has been filed. Next, paragraph. In context of the submissions made by the learned counsel for the petitioner, comma, the provisions of section 20, provision, not as provision of section 20 of the Contempt of Courts Act, 1971. Prescribes that no court shall initiate any proceedings of contempt, comma, either in its own motion or otherwise, comma, after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Full stop. In the said context, it is observed that the authorities of the BTC, including the Director of Education, BTC, were not parties in the writ petition.
But my lord, may I just, but here the SC BTC was appeared, my lord. I think it is not reflected, but in the writ petition it was included in page 12. And Bodolai as standing council BTC was there. So I think, my lord.
Yes, Mr. Musari, this district elementary education officer Nalbari, is your authority?
Earlier occasion he was under that question.
No, but who is the respondent? BTC, who is the respondent amongst 5? 6 people are respondents here.
Yes, madam.
Who is BTC?
BTC, for the director was made party, madam. The petition, it may be main lead petition, I am not know.
I don't know. I'm passing orders on basis of what is there available.
But in the first title, name of the council's mail of SC education.
No, that is okay, but
But the BTC party is there, madam. So
but-
without being implemented, it should not have been mentioned, madam.
no, I don't know. I'm going by the order sheet.
BTC was party there.
It could not have been.
Standing council, para 2, it is mentioned, madam. Education board consultancy by the government was completed. G Mohilari was for 7 and 8 was added, madam. And the page 13, it is mentioned there, MS G Mohilari, landed council for the respondent number 7 and 8. Here 7 and 8 is not mentioned in the order. 7 and 8 was in the main petition
Where?
was added, madam.
Where?
Lordship point in page 13.
Yes, I'm there in page 13.
Yes, madam.
Where?
For first para, respondent number 6 G Mohilari, landed council for the respondent number 7 and 8. She was at that time BTC council appeared. 7 and 8 was added, implemented later on. Yes, BTC was implemented. We are only up to 6 treasury officer and 7 and 8 in the main lead petition. I was allowed to implement.
Okay, okay. It appears that the BTC authorities were represented.
Lordship,
Sorry for Lordship interfering. Lordship, on the last occasion, court directed me as a standing counsel to get the instruction. Lordship, I have got the instruction. Lordship, may kindly bear with it.
It appears from para 1 of the order dated 23/4/2015 that respondent numbers 7 and 8 were represented by the standing counsel for the BTC. Be that as it may, in so from the order dated 17/12/2018, passed in Concase C 260 of 2016, it appears that the stand of the Director Education, BTC, in an affidavit filed therein, affidavit in opposition filed therein, was to the effect that the authorities in the BTC had not received any representation from the petitioner for carrying out the order dated 23/4/2015, passed in WPC 3625 of 2017. So as the petitioner had not controverted this said stand, this court had closed the writ petition, granting liberty to the petitioner to approach the court again if so advised. The petitioner, before next paragraph, the petitioner, before approaching this court, had submitted a representation dated 8/4/2019 to the Director of Education, BTC. And thereafter, the present contempt was filed on (25/9/2019). Therefore, in terms of the limitation prescribed in section 20 of the Contempt of Courts Act 1971, the present application is held to be barred by limitation. The court is further inclined to hold that merely because in order dated 17/12/2018, passed in Concase Civil 260 of 2016, this court had granted liberty to the petitioner to approach the court again, would not be sufficient to extend the period of cannot be construed to be an order by which period of limitation prescribed under section 20 of the Contempt of Courts Act, 1971 has been extended. Next paragraph. At this juncture, the Mr. B. Chaudhary Leonard, standing counsel for the BTC, has submitted that he had that although he is not appearing for any of the respondents in this contempt petition, he is appeared as directed by this court by order dated 27/2/2023. And it is submitted that as standing counsel for BTC, he has obtained, he has received instructions by letter dated 23/3/2023. That the petitioner was appointed by the then Deputy Inspector of Schools, Nalbari, in the year 1999, before bifurcation of Nalbari district to Buxar district, and his service was terminated by the Director of Elementary Education, Assam, on 26/12/2006. And therefore, the Director of Elementary Education, Assam, is the sole authority to clarify the matter, since the BTC does not have any records in connection with selection, appointment, and or other service record of the petitioner. Accordingly, the learned standing counsel for the BTC has submitted that as the appointment of the petitioner was made by the Director of Elementary Education, Assam, the BTC authorities would not have jurisdiction to take any decision in the matter of the petitioner, who was appointed by the Director of Elementary Education, Assam, and that his service records were that his service was never placed before the Director of Education, BTC. Next paragraph. In view of the period of limitation prescribed in under section 20 of the Contempt of Courts Act 1971, the court is constrained to hold that the present application the present contempt petition in respect of order dated 23/4/2015, passed in WBC P65 of 2007, having been filed on 25/9/2019, was beyond the period of limitation. Next paragraph. be the as it may. As the petitioner was already granted liberty by order dated 17/12/2018, passed in con case C 260 of 2016. And having narrated the instructions which is now provided to the Learned Standing Council for the BTC by the Director of Education, BTC Kokrajhar. The petitioner may be well advised to approach this court in an appropriate manner as per leave grant by order dated 17/12/2018, passed in WBC. Sorry, passed in con case C 260 of 2016. Accordingly, this contempt petition being bad by limitation stands closed. But Mr. Chaudhary,
Yes, my lord.
although I'm dismissing this contempt petition, but I'm not very happy. You see,
Yes, lord.
in the contempt petition, you say that the BTC was not given any representation. Therefore, he withdraws, that is closed, and he files a representation. Now you come up with again a stand that the BTC is,
Non-availability of records.
then
That's what law said.
where does it go, in fact?
I think though he have submitted the representation to verify with the record, that was not handed over by the by Federation of Nalbari District Lordship. Maybe for that it is pending still.
But you are washing off your hands, saying that you are not the appointing authority. Now, in the BDC areas, the teachers are appointed by whom?
Lordship, new selections are first of all done by a board, selection board.
By the BDC people.
Yes, BTC, within the BTC area, and the secretary is the main appointing authority. Lordship.
He is the appointing authority.
Yes, Lord.
Okay. Your instructions you take back tomorrow, because she may require while transcripting.
Or Lordship,
Yes.
I can give a photo state, Lordship.
The first page.
Yes, Lord.
Mr. Nath, we are still giving you the liberty to approach the
Yes,
court
yes,
again.
yes, I have to approach again. Obliged. Lordship, this case may be taken up after federation, Lordship. After federation, I have told my non-friend.
On the, both sides are duly represented. On the prayer made by Mr. R.C. Saikel and counsel for the petitioner, the list this matter after answering due petitions.
Yes. Obliged.
Yes,
May I please know what question was taken upon the respondent number 6, my lord, by registrar for the usual process of court, my lord, the pursuant to order of the consumer court, my lord. And office note dated 17/3/2013 shows that my lord notice was received by the brother of the respondent number 6, my lord.
So notices served
Lordship, I am appearing for the respondent number 7. Lordship.
for number 7. Not for 6.
Only for 7, Lordship.
Okay. But Mr. S.K. Sinha, Learned Counsel for the petitioner, he is referred to the order dated 25/1/2023, passed in the proceedings of Lahozima Court, by which notice was deemed to be duly served on respondent number 7. Mr.
Jay Hatimuria, Lordship.
J. Hatimuria, Learned Counsel, appears for respondent number 7. Yes. You want to say anything?
Lordship, I have also applied for compensation of appointment, or as far I'm selected, I was.
No, that is okay. You have to say anything today. Today you want to say anything? No.
No, Lordship.
Okay. Next para. Also seen the office note dated 17/3/2023, indicating that service report is received from the Court of Learned Mansib number 1, Dibrugarh, with the report of the process server stating that the notice was handed over to the brother of respondent number 6. Now appears on call for respondent number 6, although notice is accepted to be duly served. Next para. List the matter in the admission column. On, give a date, sometime.
8/5. 31.
May I please, your lordship, my lord?
Yes.
My lord, the matter relates to 2019, my lord, wherein we have challenged the TAT examination conducted at the relevant period of time, my lord. My lord, perhaps the matter has become infructuous, my lord, and I am out of touch with the clients also, my lord.
Okay.
So, my lord, may I pray that a 2 weeks time may kindly be given, my lord,
Okay.
updated.
On the prayer made by Mr. A.R. Bhunya, Learned Counsel for the petitioners, matter stands adjourned to enable him to obtain instructions as to whether the
So is alive.
whether the issue is alive or not.
My lord.
Stop. List in the week commencing 15
May, my lord.
May.
My lord. Obliged.
32. 32.
Yes.
My lord, probably I had to again resubmit my applications for compliance because during the pendency, my lord, new incumbent had joined, my lord, in place of 1, 2, and 3, my lord. As per my instruction, my lord, Mr. Sahnawaz Chaudhary has joined, my lord, Mr. Narayan Kaur, secretary, and in the district implementary Karimganj, my lord, Iqbal Hussain. So I have to give the fresh representation, my lord, along with the enclosures, and then I have to come again, include them as a party.
No, you want to include whom?
In place of 1, page 2, my lord. In place of Mr. Pritam Soitia, I have to edit party as Sahnawaz Chaudhary, my lord. And in place of.
No, this is item
32.
item 32.
33, my lord.
32.
No, this is 32.
I'm sorry, my lord, I'm sorry.
None appears on call for the petitioner. Stop. This interlocutory application has been filed for restoration of WBC 7948 of 2018, which was dismissed for non-prosecution by order dated 19/11/2020. Next one. This done appeared for the petitioner when the petition of the matter was previously listed on 26/9/2022. Today is the second date when the petitioner is remained absent on call. So, matter since adjourned for the ends of justice, it is made clear that if the petitioner remains unrepresented when the matter is listed next, the court will be compelled to dismiss this introductory application for non-prosecution. List after 4 weeks. Yes. You want to include whom?
My lord, I'm page number 2, my lord. In place of Mr. Pritam Soitia, I'd like to include Sahnawaz Chaudhary, my lord. And
No, his respondent number
1,
and
2, Mr. Narayan Kaur, and 3, my lord, Iqbal Hussain Balwiyan.
okay. Upon instructions, Mr. A.S. Tabadar, learned counsel for the applicant submits that new incumbents have joined the office of respondent numbers 1, 2, and 3. So you'll have to file a fresh application, and accordingly, he does not press this interlocutory application as new incumbents are to be implemented. Next para. Accordingly, this interlocutory application stands closed. Next para. However, as prayed for, the learned counsel of the petitioner however, as prayed for, the petitioners petitioner is the connected contempt petition at liberty to put the new incumbents to notice of complying with the order of the court and file an appropriate application for impeding. So this IA is closed.
I'm with you.
Okay.
34.
Yes.
Lordship, I apologize, we missed the matter today, Lordship. My senior's name has not been reflected. Kindly may the matter be taken up after review vacations. My senior's name may be reflected.
I did not get it. Who's the counsel for the petitioner?
Mr. UPN,
No, but his sitting counsel, Mr. MP Sharma, his name is reflected here.
Lordship, kindly my senior's name may be reflected in.
Also, dispose of matter, Lordship, interlegal order petition is filed, Lordship. To compliance of the order, they have filed a contempt petition, Lordship. That closed, Lordship. And because of that order, there is some legal right, Lordship, the submission from the petitioner, Lordship. And to approach, granted in the.
No, it's
contempt
okay.
petition.
You see, he is a senior counsel. We are not.
Yes.
You just making appear. We can't. He will appear on instructions, right? He can't be an advocate on record. So even if his name is not shown, you just correct.
Otherwise,
it would be.
Lordship, a day may be fixed. After being vacation.
Okay. It is after view vacation as paid for by London Council for the petitioner. The registry may reflect the name of, sorry, it is Mr. S. Meher, standing counsel for the Higher Education Department, and Miss
P. Sharma, Lordship.
P. Sharma appearing on behalf of standing counsel for APSC represent. The registry shall reflect the name of Mr. U.K. Nair, senior counsel, in the cause list for the petitioner while listing the matter next. applicant, for the applicant. Okay.
35.
Today morning, somebody made a, Mr. B. Kaushik is gone to the treatment of his brother.
Yes, my recourse is out of station, my lord. Due to his father.
On behalf of Mr. B. Kaushik and counsel for the petitioner, the prayer for adjournment is made by Mr. U. Sharma, rather than standing counsel for Elementary Education Department. Secondly.
And you.
Oh, you will do it?
No, I don't have that brief. Madam.
Oh, okay.
Since he's not present, madam, that's why.
Okay. Mr. S. Chaudhary, counsel for the respondent is present. So, matter is adjourned today, based on, when did you fix the earlier matter? 26th.
26th of May.
Last matter we fixed when? Mr. Mazumdar had made a prayer.
I'll confirm, madam. I'll confirm and give the paper.
28/4.
28/4.
Deeply.
36 and 37.
But this is a review petition preferred by the state, madam.
Yes.
Seeking review of the order dated 19/11/2019. Passed in WPC number 5042/2018, madam. The relevant order is at page 46, madam. Order under review is at page 46.
Just a moment. Okay, notice is served.
Yes, madam. My learned friend.
Yes,
Oh, you are appearing.
Is appearing, madam.
Okay. Yes, why we should not entertain this review? 9 years.
Lordship, the fact is that I can understand that 9 years, but the error apparent on the face of the record, there is nothing on this record which has not been taken into account by this honorable court while passing the impugn order. Because they did not file any affidavit in opposition. They can better prefer an appeal. Because how this review is maintainable at this stage, because there is no error, because they could not file any document, they did not produce any record before this honorable court at the time of
No,
disposal
but
of the
the
record.
calculation itself is sufficient. If it is 9 years,
Yes, Lordship.
then even without an affidavit, we can still interfere.
No, without an affidavit that can be interfered, Lordship, but the fact is that review, it's a review of the order. In that particular order, this honorable court, if your Lordship kindly see the order of this honorable court, it is at page number 47. All relevant aspect of the matter has been dealt with.
Show me that.
Because if your Lordship kindly see the page number 47.
Yeah, I'm there.
Yes, page number 48. Paragraph number 6, Lordship. Paragraph number 6.
No, but this, the fact that if this birth date is taken, he would have been a minor on entry into date of service. That is not reflected here.
Now, Lordship, kindly see the paragraph number 6. The court is of the view that aforesaid order issued by the DEO is in variance with the decision of the state government to correct the date of birth of the petitioner of his service based on the certificate issued by the Secretary Board of Secondary Education Assam. Since the aforesaid impugn order is issued by the DEO, which is an authority subordinate to the Director of Elementary Education. That was completely verified, Lordship, because I produced all the
No,
relevant.
I understand. You see, I
Yes.
bring a certificate. Today, I am showing a certificate which will have the effect of me joining service in the age of 9 years.
So that was a mere office boy lordship. In the writ petition also, we have specified everything lordship. Because there is another judgment of this honorable court with regard to same issue, same aspect of the matter where the person has joined at the age of 9 years. That particular period was not taken into account. And subsequent, after the age of attaining the majority 18 years, that was taken for computation of the pension. This is the judgment of this honorable court, lordship. So it's not a illegality, that was a mere irregularity. Because the service was
No, that may be held, but even for that purpose, we'll have to entertain
because
this review.
first of all, lordship, they have to specify the thing why this review is maintainable. Because there was no document able, because the basic requirement of the review is the error apparent on the face of the record. Why is that error? Because the honorable single judge, while dealing with this matter, while disposing the writ petition, very well defined all these aspects of the matter.
But did not take into consideration the age was 9 years. He would have joined
Exactly,
service.
lordship, because the subsequent verification by the concerned officer, he has verified all the relevant documents, and accordingly, after getting information from the Sheva with regard to his age, that was that letter was issued.
No.
The appeal letter was issued.
It's okay. But can anybody join service at the age
No,
of 9?
I can understand that, lordship, but it's a subject matter of the appeal. They could have preferred the appeal, but how they have preferred the review? Where is the error apparent on the face of the record?
Because you see, the theory is different.
Yes.
The theory
It
is
not different.
no, the theory is different.
Yes.
You see, it would amount to a fraud.
No, that was not fraud, lordship, because at the time of joining the service, if your lordship kindly see the service book.
No, I could have understood. You
Yes.
see, if in your writ petition you say
Yes.
that if the writ petition is allowed, I would have joined at 9 years of age. So therefore, my service benefits would accrue from when I was an adult.
Exactly.
If you have not said so, so it is a principle of
No.
fraud, and then I can surely invoke
That
the-
was that paper was made. The writ petition was filed only with regard to correction of the date of birth, because this particular issue was dealt with by this honorable court. While adjudicating the issue, then this honorable court has passed an order explaining that aspect of the matter. If he has joined at the age of 9 years or 7 years or 10 years, something like that,
Have you said that in your writ petition?
lordship.
Have you made that statement in the writ petition?
No, that statement was not there. My specific prayer was for correction of the service book.
But
Because what I stated, because the concerned authority has issued a letter, pursuant to that letter, I am entitled for getting certain benefit. What is that benefit? I may be extended certain period of time because of the certificate that has been verified by the authority.
what is the effect? That's what I'm saying.
Effect is
I would
can
have-
be
I would have understood if you have said
Yes.
that in the writ petition. If the disclosure is not made in the writ petition, the decision would have been different otherwise. Had I known that if I pass an order, this person would have gone into entry into the age of service would be 9 years. Had I known it, I would have taken precaution in my order.
No, the calculation was there, lordship. Because in the writ petition, what I have stated at the time of joining my service, everything is narrated in my writ petition.
Where is it?
Calculation is very
Where
much
is it that I
apparent
joined?
from the record.
Where did you say that I joined in the age of 9?
Exactly, Lord. No, that was not specified, but the data is specified, the 76.
This amounts of fraud.
No, data is specified, lordship, 15/11/1976 can very well be calculated at that point of time.
No, you think I have time to make that calculation when I'm passing an order?
Yes, lordship.
Do you think I have so much of time when I'm passing an order?
But that should have been brought into record by the Learned Standing Council who was there.
That's a mistake. when
Yes,
they-
Learned Standing Council. Now, the mistake that has been done, whether it can be corrected by your filing a review.
Yes. I would give you a right of appeal.
Let me file my objection, lordship. Let me file my objection.
Do it.
In fact, my lord, the affidavit was prepared by his son.
No, let him file an affidavit.
Yes, Lord. Let me
Don't
file.
worry. Both sides are duly represented. On the prayer made by Mr. SP Chaudhary and counsel for the respondent. I understand that John would enable him to file affidavit in opposition in the matter. This after.
After 2 weeks, lordship. After this ensuing in the month of May, lordship.
List after ensuing new vacation.
Obligation.
RTI
Next, चल रहा है.
Yes.
My lord, see the order dated 19/10/2022. I am, my lord. Now this petition is in a very narrow campus, my lord.
You want this matter, petition to be taken up for early hearing?
Yes, my lord, the situation was such, my lord, that we had to file this application.
That's okay.
And my lord,
Yeah, you are ready for hearing?
yes,
Okay, yes.
we have filed one additional affidavit if the lordship would take up.
Oh, just a moment, before I take up your matter for hearing. This item 41 is also for hearing. Who's there for the bank is, somebody's there? No. It also is not there. Okay, then I will allow your application. After some time, then let me complete this. Okay.
The petitioner at that point of time was studying under respondent number 4, my lord. She was in the engineering stream, my lord. And in one of the papers, engineering mathematics, my lord, she got 29 marks. He submitted an application to the university for revaluation of the answer script, my lord, which is permissible under their scheme. And we made necessary, the payment, necessary payment of fee was made, my lord, and the results were not disclosed to us. Subsequently, we had to file the writ petition, my lord, seeking your lordship's intervention. In their affidavit, my lord, they took a stand, my lord, that before the writ petition was filed, my lord, they have evaluated the answer script and no discrepancy was found out. During the pendency, my lord, an RTI application was filed by petitioner's father, my lord, regarding the procedure of re-evaluation. But they did not respond, my lord, and thereafter petitioner's fathers filed an appeal, and appeal, my lord, they were directed to give this response, and that response is there before your lordship in the additional affidavit at page 109, my lord.
No, you had got
29 marks,
29 marks.
my lord.
So which is below the
30 marks, my lord.
30 marks.
Yes.
Yes.
At page 109, my lord, you also would see the reply dated 5/7/2009.
109.
Yes. Annexure B to the additional affidavit.
Okay.
In response to the above mentioned RTI, it is to inform you that the re-evaluation step is followed by appointing an alternative examiner than earlier original examiner appointed by Guwahati University Authority to evaluate the answer script after covering the marks given by the original examiner. Well, the only issue is whether they have done it. Now, they say they have done it, not let them produce the record before your lordship, and your lordship would be satisfied whether this exercise was done or not.
No, I think when Mr. Fukan is producing something before the court, he has satisfied himself.
Well, in fact, the answer script was also directed to be produced before lordship in seal cover. It was produced after the first problem. Thereafter, your records are here.
Prior to that, my lord, earlier order of this honorable court, dated 9/12/2016.
Okay, what is that?
Regarding, my lord, seal, result in seal cover, my lord, that was open on that day, my lord,
Yes,
9/12/2016.
yes, I've seen that. Seal cover is open.
And no sense, Miller. No
Huh.
sense. The result is no sense regarding modus meter folder,
Yes.
serial number 5. Subject code MA101. And it has also been reflected in the original records.
Because so far as Mr. Fukan is concerned, his actions are predictable. We went to same guru.
I'm doubting the intention of the university authorities.
Okay. But guru in the literal sense, not in
Perhaps
the
the correct instructions have not been passed on.
guru in the literal sense, not the what you call
Metaphorical sense.
visual sense.
They have filed too many affidavits, my lord, but none of them they have disclosed whom they have appointed as a re-evaluator. How the process was done.
No, I think that they will not disclose. They'll merely make a statement because it will be only when the answer scripts are called for.
Answer script was called for by your lords.
Here it is same, no change.
No sense, Miller.
That result we
You
know.
have the answer script also.
No, Miller. Answer scripts have not been called for, Miller, as yet.
You said it was called for by which order?
This is the very first order, my lord. In seal cover.
On 27/10/2016, the result has been directed to be in seal cover and to be placed
No,
before.
in the 27/10/16, the order is that in the meantime, Guwahati University may carry out re-evaluation of the answer script of the petitioner in the engineering mathematics paper of first semester held in January 2016 and place the same in a seal cover before the court.
And then, Miller, next order was passed on.
Next date only
9/12.
next date only evaluation sheet was produced, not the answer script.
Not the answer script, only evaluation.
So we did not have any privy to see what was there, whatever in there. Because before the lawsuit.
Because I can tell you, if there's no change in the result sheet, then in the answer script also, you'll just find that the evaluation done and it will just be signed. There'll be nothing in that evaluation sheet of what is it, but still, can you produce it?
Miller, it will be difficult, Miller, since Miller, after 6 months, Miller, the records.
No, but once there's a court case and you have done revaluation by the order of the court, I don't think you'll destroy it.
My instructions are that was done at their university by the same person. No changes. Therefore, even they were not eager to give me the reply. What is the procedure? Once that given, Miller, at least they
Executive
ought to have
Council
followed that.
decision, Miller. Passed in 2009, Miller. Answer script, holding period, 2009.
Just try to get information when the authorities will give it tomorrow.
my lord.
By tomorrow you get information. If you can do it by tomorrow.
Tomorrow, my lord. Day after tomorrow or my lord. After
No, they will fix it after vacation because, well, I have to keep my matters due. I have to sign all orders and then go.
my lord.
On 12th, normally all orders are uploaded in my courtroom.
That will be after vacation only. my lord.
19/4.
My lord, not on those 3 days, my lord, on 27, 28, my lord. 26, 20, 27 will be better for me,
26 then,
my lord.
26.
26. 27, my lord.
27 is a hearing day. I'm trying to avoid that.
My lord, 26.
Both sides are duly represented. We allow this application and put this matter for hearing on 26th. This interrogative application I'll allow. Interrogative application. For Mr. R. Dubey and counsel for the petitioner, for the applicant, and Mr. P.J. Fukal and standing counsel for the respondents. Next, this interrogative application is for out of turn hearing of the connected writ petition. First off, as career of a student is involved in the writ petition, this interrogative application stands allowed. This is the matter for hearing on 26/4/2023.
Yeah.
In this writ petition, you write both sides are duly represented. Mr.
My lord, respondent number 4 and 5. Central Institute of Technology, my lord, Kukreta. I am for respondent number 1, 2, and 3.
25, we had served justice service, my lord. They did not represent.
Page number 3, my lord, writ petition. CIT represented by director and 5 the director, CIT, Central Institute of Technology, Kukreta.
Okay. So, Mr. P.J. Fukal, sorry, Mr. R. Dubey and counsel of the petitioner has referred to the order dated 27/10/2016. Whereby the Guwahati University was permitted to carry out re-evaluation of the answer script of the petitioner in engineering mathematics paper of first semester held in January 2016 and placed the same in a sealed envelope before the court on the next date. So it is submitted that on 9/12/2016, the evaluation sheet was prepared in a sealed envelope. And this court had recorded that the evaluation was completed on 6/9/2016. And as per the re-evaluation statement, there is no change in the marks awarded to the petitioner. Next, the learned standing counsel for the respondent numbers 1, 2, and 3 has submitted that the re-evaluation was done prior to
27.
passing of the order dated 27/10/2016.
And result was declared on 6/9/2016.
And results were declared on 6/9/2016. On a query of the court, the learned standing counsel for the respondent numbers 1, 2, and 3 has submitted that as per the executive council decision taken in the meeting held on 27/11/2019.
2009.
2009. The time period for holding answer scripts for evaluation is 6 months. And accordingly, it submits that he would have to take instructions as to whether the answer script of the particular answer script of the petitioner is still in custody of the university authorities. Full stop. Next, accordingly, it is provided that if the answer script of the petitioner in respect of
Engineering mathematics.
engineering,
Mathematics.
mathematics, paper is still available with the university authorities, or the same may be produced in a seat cover on the next date. List for hearing on 26/4/2023.
Deep development.
May I please your lordship. Lordship, implement application, my lord. Respondent 1 and 2 have retired now, my lord. They've been replaced by respondent 3 and 4. my lord.
Okay. Where is the document that you have put them to notice?
My lord, then additional affidavit was filed on 17/3/2023.
Yes, which document?
There, my lord, page 23, my lord. Notice dated 1/2/2023. Notice at page 23 and the delivery reports are at page 38 and 40.
Okay. But Mr.
HK Sharma.
H.K. Sharma, and counsel for the petitioner. Mr. Thanks, sir. This interrogatory application has been filed for implementing the opposite parties number 3 and 4 as respondent numbers 3 and 4 in the connected contempt case 634 of 2017. It is submitted that the parties sought to be implemented were served with notice dated 1/2/2023 requiring them to comply with the order of this court dated 16/2/2017 passed in WBC 3921 of 2012. Next, accordingly, issue notice return on so and so. The petitioner shall take steps for service of notice on the opposite parties number 3 and 4 within 2 days. By this proposed with the current counsel for the petitioner is that For the applicant is at liberty to correct the postal receipt number from the registrant to submit postal track report prior to the next date of listing. Notice is made returnable on, give a fixed date for appearance,
15/5,
list accordingly.
much of it. 40,
Please, your lordship, there was an interim order. These persons were appointed in pursuant to resolution of the governing body. And accordingly, they have been working since last 20 years. So as we are not regularized, we have approached this honorable court. There was an interim stay in our favor. Now, once again, the college authorities went ahead to advertise the post. So again, we came up with an I, and this court has stated that, directed that one post should be kept vacant. And recently, your lordship, the college authorities have issued advertisement which is at page 31, your lordship.
What is the prayer in the writ petition?
The prayer in the writ petition is to consider our regularization, your lordship.
No,
And
but
to
for
pro-
regularization, you can't stop an advertisement.
No,
You may have a right to participate, but your regularization can't stop
no,
a.
that is our post, your lordship. There is a stay operating in our favor, your lordship. And again, we have filed an IA, your lordship. Once more, the advertisement was issued. If your lordship kindly come to page,
What is your right for regularization?
your lordship, there was the issue was like this, your lordship. There was a resolution of the governing body pursuant to which we have been appointed, your lordship. And we have been working for the last 20 years, your lordship. Those are sanctioned posts, your lordship. And there was a move by the authorities to consider our case and to regularize. So there was a stay order operating in our favor, and there is nothing from the DHE directing that to advertise the post, your lordship. If your lordship kindly
No,
come.
you see, after post Uma Devi, regularization can't eat up the regular post. It has to be by way of a public advertisement. You can't be, your regularization can't be made post Uma Devi.
The minor days recently.
Just a moment.
Your lordship, we have been working prior to the coming to the effect that of Uma Devi.
No, but still, you see, it's a special bench decision. I can't, with my order, can't override a larger bench decision of Supreme Court.
Your lordship, otherwise this matter can be heard, but the thing is that there is a stay order operating in our favor, your lordship. It's
No,
not
but
a-
still, how can I stay the employment
No, I'm not
process?
saying that stay the entire advertisement. There are many posts. I'm only saying that as this honorable court is directed to keep one post vacant for me. In fact, on another occasion
No, you
also,
see, you show me the right that you have, for regularization, you have a right.
your lordship will fix the matter. Your lordship will kindly come to page 29.
No, I'm prepared to take up the hearing. Let me finish Mr. Chakravarti's matter first, then if you want, I will take the matter hearing now only. Because you have to demonstrate your right. Once you can demonstrate, you have a stay order.
Lordship,
Because
the stay-
employment process.
As on date, your lordship, the plain and simple is that there is a stay operating in my favor.
No, but employment process, I can't stop.
No, I'm
You
not
wait-
saying to stop the
You
entire
wait,
process.
you wait for some time. Let me complete Mr. Chakravarti's matter. He has been waiting for many days. Let me complete that. Then I'll come back to your matter.
41,
My lord, the order which we are seeking review, your lordship will find that page, it starts.
Just a moment. Just hear the order and correct me where I go wrong. Heard Mr. S. Chakravarti, learned counsel for the petitioner. None appears on call for the respondent. Next paragraph. At the outset, it may be mentioned that a copy of affidavit in opposition filed by the respondents, which was sworn by one Chandaneswar Goswami, Chandaneswar Goswami, Zonal Manager, Indian Bank. Was served on the learned counsel for the petitioner on 2/1/2023. However, the registry has reported that as per the filing section of the registry, no such affidavit has been filed. So the said statement is recorded in order dated 5/4/2023. So accordingly, the learned counsel for the petitioner was asked to make a photocopy of the affidavit in opposition served on him and provided to the court master. First of this said affidavit has been produced, a copy of the said affidavit has been produced by the learned counsel for the petitioner. First of, in the said context, the learned counsel for the petitioner has submitted that on receipt of the said photocopy, he has also filed an affidavit in reply in the matter. First of, the affidavit in reply filed on 1/2/2023 is on record. Next paragraph. This review petition is directed against the order dated 3/6/2022, passed in WPC 3394 of 2018, to stop. Next paragraph. The case of the petitioners, review petitioners, is that this court, while disposing of the writ petition by order dated 3/6/2022, had accepted the statement made by the learned standing counsel for the respondents, i.e. the Indian Bank, whereby stand taken by the respondent in their affidavit in Indian Bank in their affidavit of opposition whereby they had denied that any interview had taken place as projected by the petitioners. And this court had accepted the statement of the counsel for the respondents that the interview process was kept in abeyance on 13/1/2016 as per instructions issued by the Ministry of Finance dated 22/12/2015, by which the ministry had recommended discontinuation of interview in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015. First, next, the Learned Counsel for the review petitions. I submitted that the petitioner had applied for appointment to the post of sweeper,
Part-time sweeper.
part-time sweeper in the
My lord, that
in-
time it was Allahabad Bank when the advertisement was.
in erstwhile Allahabad Bank, which is now merged and is now known,
Merged with Indian Bank with effect from, my lord,
is known as Indian Bank with effect from
1st April 2020.
1/4/2020. Full stop. Accordingly, as this court was of the opinion that there is nothing on record to show that in violation of the policy decision for recruitment, the respondents have been engaging others while leaving aside the consideration of the case of the petitioners. This court had directed the respondent number 2, I, the general manager within bracket HR, bracket closed, Allahabad Bank, to take appropriate decision and to convey to the petitioners about the status of their applications, which were submitted pursuant to the appointment advertisement dated 30/11/2014. Next one. The Learned Counsel for the petitioner has referred to page 24. This is Chakravarti, page 24.
My lord.
Has referred to page annexure B1 at page 24 of this review petition.
From B to F.
Huh?
Annexure B to annexure F.
Achha,
These are the
B to
F. Annexure B to annexure
Achha,
F.
B to annexure F of the writ petition. Don't give the page. The project that various branches of Allahabad Bank had conducted interview on various dates for recruitment of part-time sweeper.
As per
You-
the
you-
advertisement dated.
You are
30.
given a chart. Where is that chart?
Yes, my lord. That is page 52 of the additional affidavit. I mean, the affidavit in reply. It starts from. It's the paragraph number 7, 51 and 52.
Okay, in this regard, referring to the affidavit in reply filed by the petitioner on 1/2/2023, it is projected that interviews were held in 17 branches. And that in respect of 2 branches, no applications were received, and therefore no interview could be held. This page or flag at page 40.
51 and 52.
No, now it is 40. Full stop. What stand did they take in the
Affidavit paragraph 6, they say that interview was not held in all the branches at the same time, in some branches, but they have not disclosed in how many branches. And they are saying that interviews were not completed in all the branches, suppressing the fact that in 2 branches interview could not be held for want of application. Paragraph 6. Earlier stand.
Para 6? Read that para 6. Where is it?
That with regard to the statements made in paragraph 3 and 4 of the review petition, the answering respondent states that the interview for the advertised post was conducted in some branches, but not all on the same day.
Okay.
Earlier, no interview, now in some branches.
Okay. In next para, in this regard, referring to the stand taken in paragraph 6 of the affidavit in opposition filed by the respondents, which is not on record, is as follows. Para 6 separately. Like it. Next para. Next para. This matter was listed on 3/4/2023, and on the prayer made by learned counsel for the petitioner respondents, the matter was adjourned to 5/4/2023. On 5/4/2023, none appeared for the respondents, and accordingly, the matter was adjourned for being listed today, i.e. 10/4/2023. Full stop. This matter was taken up for hearing at 4 p.m., but the counsel for the respondents did not appear in the matter. So accordingly, the matter was heard in the absence of the learned counsel for the respondents. Next para. In this case, the learned counsel for the review petitioner has been able to demonstrate that although interviews were held in 15 out of 17, 19,
17 out of 19.
okay, in 17 out of 19 branches of erstwhile Allahabad Bank, now merged with Indian Bank, interviews were not held only in respect of 2 branches. And accordingly, the court is satisfied on the point that despite due diligence, the petitioner could not produce documents to show that interviews were held for the post of part-time sweeper, despite purported ban in holding of interview.
No, my lord, the ban is something different. Our case is the notification came after the interviews were held. So our case is this notification cannot have retrospective effect
Okay.
on the post advertised.
Okay. The interviews were held. It is projected by the Land Council with the petitioner that the purported banning order came into effect from
My lord, the order was issued on 22/12/2015,
22/12/2015.
by which all banks
But the interviews were held
and
prior to
completed.
the interviews held prior to the date on which the banning order became effective. Accordingly, it is the case of the petitioner that the purported banning order would have no effect on the interviews already held, as such order could not be given a retrospective effect. Full stop. Next, accordingly, on being satisfied that at the time when the connected writ petition was heard, the petitioner could not produce the relevant documents despite due diligence. The court finds that this fit an appropriate case to invoke the jurisdiction and to invoke review jurisdiction of this court. And accordingly, the court is inclined to recall the order dated 3/6/2022 passed in WBC 3394 of 2018. Next paragraph. As a consequence thereof, the proceedings of WPC 3394 of 2018 stands restored to file. Next paragraph. This review petition stands allowed.
My lord,
Now, in that writ petition, you write, in view of the order passed today, I'll be Chakravarti. None appears on call for the respondent. In view of the order passed today, in the connected review petition 158 of 2022, the audited so is recalled, and this writ petition is restored to file. This is the matter for hearing on.
any date, my lord, immediately after vacation,
Okay. On
19th.
no, not 19th. This we'll fix it on 26th.
Month.
26/4. Yes, you were saying
Another
something.
thing, my lord, that is also a case that the bank has suppressed, not only made suppression of facts, they have deliberately misled your lordship. Lordship will see from the 2 affidavits, it is deliberately they are misleading your lordship. So, my
It's
lord,
okay, I've restored it.
my lord,
When we hear you on that day, we'll take note of it.
and this, because of this deliberate suppression and misleading facts, the petitioners were not
It's okay, I've accepted your
given
submission.
the justice which they were otherwise entitled to at that point of time.
I've accepted your submission. the photocopy of the affidavit in opposition. As served on the Law and Council for the petition, for the petitioner is retained as a part of record.
And my lord, my name may be shown in the writ petition.
Okay. In the repetition, you write. This order obtaining will be in IA. And in repetition, that the registry shall reflect the name of Mr. S. Chakraborty as counsel for the petitioner while listing the matter next.
Right.
As well as name of Mrs.
S. Chakraborty.
No, I'll return full name. What is the full name?
Sangeeta Chakraborty.
Okay. And also reflect the name of Ms. Sangeeta Chakraborty as counsel for the respondent while listing the matter next. Yes, now 40.
Wait, please, your lordship. Can this matter be taken up on Wednesday, your lordship?
Wednesday is 12th. 12th, I am not burdening myself.
Mr. Nair has requested that the matter
I
be
can
taken
take it up on 19th, I can take it up on 21st.
By then, the post might be filled up, your lordship.
No, but 12th, I am not burdening myself. Because I have to finish all work, upload all the orders and then go home.
Otherwise, your lordship, the issue is in a very narrow compass, your lordship. There is already a stay operating in my favor, your lordship.
No,
In
that
spite
may be
of that-
so, but you will have to only demonstrate, the only fact which you'll have to demonstrate is that from the, what is your vested right to have this?
Your lordship, may I just present this case in this manner? That these persons were appointed by resolution of the governing body and accordingly they have been working since 2003. Now, thereafter, there was a move to regularize these petitioners in a phased manner. And many of them have been regularized. But my name was dropped, your lordship, including with many other persons similarly situated in many other colleges. Accordingly, this honorable court, after hearing us in writ petition 8817/2018, had stayed to the extent that our post should be protected because our names were dropped. It is not the case that only there was a move, there was a resolution, there was a notification that these people has to be regularized in a phased manner. Accordingly, many persons have been regularized, but some of the people have been dropped in the process. So we came up before this court protected us. Then there was again a move by this honorable court. By the respective college authorities, but not by the Director of Higher Education. That they started again advertising the post. We approached this honorable court. We made a fair submission that we don't want to stall the entire process. We said that it should be protected only to the case of our post. Accordingly, this honorable court in the IA, which was disposed of by Justice Borua, protected our post. Now, once again, there is a move, your lordship. So my issue is that when the many similarly situated persons have been regularized and the matter is sub judice before this honorable court, why this move to again advertise the post time and again, your lordship? Rightly, wrongly, I may have a claim, I may not have a claim, as has fallen from your lordship. But
no, Mr. Sinha, you see, what I'm on is, you may have a right to participate, but to have have a earmark post for which you are to be regularized. Is it not asking something?
Your lordship, our age has already gone, your lordship. We have rendered our services since 2003 and we are in
So
2023.
we can still permit you that the authorities in terms of their power will consider your case, but you see, post Umadevi, as explained by ML Kesri, we can't have that post regularized by an incumbent, although you have rendered service. Even in this Upen Das, you see what has happened was yesterday only, or day before yesterday, I dealt with the matter. So Gogoi was there. You see, he has pointed out that even in the case of this Upen Das, writ April 45,
Yes.
the order was passed on the basis of the fact that the cabinet had taken a decision. And that was for muster roll employees. And in cases of your nature, he has produced a series of letters, directions by the Director of Elementary Education, by which even grant-in-aid colleges were stopped from making appointments. So you see, that is why I'm asking you that fundamental question. Once you can demonstrate that you have a right to be regularized, assuming that you have a right, if you can demonstrate that only, then we can give a stay, because you see, privacy, for the purpose of stay also, the three basic principles of injunction has to be followed. Prima facie case. You have to demonstrate that there is a prima facie case.
Your lordship, first there was a stay order operating in our favor.
No, stay is okay, but you see, stay is not a prima facie case.
Why am before this lordship? I'm only on this point that on 2 occasions this honorable court has stayed the matter, stayed the process. So I'm praying that your lordship may take up immediately after offering, at least during this bihu. Let this post not go where there is a
In
stay.
view,
operating.
no appointments will be made.
No,
I'm
but
very
I'm saying
sure.
that your lordship, there is a stay by this honorable court. Now, why this violation of this order? They could come up with the vacating order application. They have never came up before
No.
this court. This college authorities never came up before this honorable court with the vacating applications as on date. So at least one, I'm not saying the entire process. That submission I have already made. At least one post, let it remain vacant. Immediately after reopening, your lordship may fix any date. The hearing can be done, taken up, your lordship. There is already a stay. On that basis, I'm praying before your lordship. At least the college authority should have taken some courtesy to say, take the leave of this honorable court. There is judicial order. How can they flout with the judicial order? If I may draw your lordship's kind attention to page 30, last para. This was the IO which you filed once the advertisement was issued. Considering the above, this court therefore directs the respondent authorities may go with the process of filling up the non-teaching staff. However, 1 grade 3 post in respondent number 10 college, 2 grade 3 post in respondent number 4 college, 3 grade 3 post in respondent number 6 college, 1 grade 3 post in respondent number 8 college, and 1 grade 3 post in respondent 12 college. That is this college, Bhawanipur College, shall not be filled up. They could have challenged this order. They could have filed a vacating. They could have taken a leave of this court. Until date, they have not filed an affidavit also in this case, your lordship.
You see, the fundamental point is that what is the right against the authorities?
Your lordship,
The stay is one part.
the only point as of now, I am only in one issue, your lordship. That there is a stay order operating in my favor. They are flouting with the interim order.
No, you see, once there's a stay order, you go by that. If they violate that, there's a contempt. But in fact, if there's an advertisement which is perpetually coming up, there is an order. They are not asking for vacating of the order.
Yes.
So how will it be affected? If that,
Because my post has been included there, your lordship, which has been stayed by this honorable court.
then you go for a contempt.
Your lordship, the contempt, they can issue a contempt notice, but the process of advertisement cannot be stopped, your
So there's
lordship.
already an injunction operating. It can always be set aside.
Exactly, your lordship, but first let it be stayed, then only I can go for contempt, your lordship.
Once there is already an injunction, there can't be a repeated injunction for the same
That
issue.
injunction was in respect of the earlier advertisement which was issued, your lordship. This is again a fresh advertisement, giving a rise to a fresh cause of action, your lordship.
Where is the advertisement, the previous advertisement and the present advertisement?
Your lordship, the previous advertisement I have not annexed here, your lordship. It was annexed in the earlier miss case, but the present advertisement is at page 31, your lordship. Which
Of
is
the writ petition?
no, of the IA, your lordship, IA 878, which I filed in this case, your lordship.
Page?
Page 31, your lordship.
And the writ petition, where is the previous advertisement?
It was earlier, no, it was the earlier miss case which I have filed, your lordship. The miss case has been disposed of. The miss case number is IA 1386, annexure A2, your lordship. If your lordship takes up the present miss case, it will be evident, your lordship. 878 of 2023 is the present miss case, your lordship. Annexure A2, page 22 was the earlier miss case which I filed after there was a violation of the stay order.
This, which is your post?
In the present advertisement, down below, your lordship, serial number 7, junior assistant grade 3. One unreserved, then one SC. I belong to SC category, your lordship. Serial number 7, junior assistant.
You, this applicant is of which category? Praveen Das,
Is the SC category, your lordship.
it's an SC category.
Yes.
Are you prepared to do the hearing tomorrow?
As I have, as I'm being led by Mr. Ikanar, I asked him, he made a request for Wednesday, your lordship.
No, Wednesday is just not
I
possible.
appreciate your. Not for-
Tomorrow, if you want to do it, we'll take it up tomorrow. Because interim order, I'm not inclined.
Interim order to the extent that let one post be kept vacant, your lordship, his post, as comes in terms of the earlier order passed by this court. And immediately after reopening, it can be fixed for hearing, your lordship.
No,
That's
it's
my
not,
humble
not,
prayer before your lordship.
not supposed to be kept vacant, but they'll permit the authorities to go ahead with the selection process. You will have a right to participate, but the
Your lordship,
so,
immediately after
but
reopening, if
the appointment would be subject to orders that may be passed by the courts. Only that, best that.
your lordship can fix it up on 25th, your lordship, that's what.
No, after
requested.
that, whenever you want it in the next year, we'll do it. But we'll proceed, allow the proceeding, what they call the interview and what they call the selection process to go ahead.
Then may I make one prayer, your lordship, before this court, that his services should not be disturbed till then, your lordship.
No,
I'm already
not that-
protected.
no,
I'm
not
already
that-
protected, your lordship.
Not that we will, you see, because of the fact that once a recruitment, you just show me a way out of Uma Devi.
I'll demonstrate that in my petition, your lordship, once the hearing takes place, your lordship.
Okay. Both sides are duly represented. On the prayer made by Mr. Sinha and the counsel for the applicant, the Maharashtra Judge John today. Next, the learned counsel for the petitioner, sorry, applicant, prays for an interim protection of staying appointment to the post of junior assistant within bracket grade 3 till the next date of listing. As per the proposed, the prayer for stay is opposed by Mr. K. Govind and standing counsel for the Higher Education Department. And he submits that he is ready for the hearing as and when called upon to do so. Next part. The learned counsel for the petitioner has submitted that by virtue of order dated 21/8/2018, 21/12/2018, passed by this court in WPC 8817 of 2018. This court had passed an interim order not to fill up the post concerned. It is further projected that subsequent to the post of junior assistant in Bhawanipur College.
Yes.
Bhawanipur College.
Yes, sir.
Was advertised, the petitioner again filed interlocutory application which was registered as IA Civil 1386 of 2022. And this court had once again passed an order dated 13/5/2022 not to fill up non-teaching post.
One post, your lordship. Only one post. The order is at page 30, down below. The penalty may-
This court directed that the respondent authorities may go ahead with the process of filling up the non-teaching staff. However, one grade 3, just copy from page 30, last paragraph,
Last line.
next paragraph. In the said context, having heard the learned counsel for the petitioner as well as learned study counsel for the Higher Education Department, on the court is of the counsel to opine that the court would otherwise be bound by the ratio of the decision of the Supreme Court of India in the case of Secretary of State of Karnataka versus Uma Devi, 2006 for SCC page 1. And the petitioner shall have to demonstrate their indivisible right for regularization. First one. Next, the learned counsel for the applicants has submitted that by now the all the applicants have crossed the age for getting public employment, having rendered more than 20 years of service. Next paragraph. Considering the same, the court is of the constitutional opinion that the petitioners, the applicants will have liberty to apply for being appointed in the advertised posts. And if they are overaged, they may approach the concerned authorities, the competent authorities, for relaxation of age, which would be dealt with on case-to-case basis. Postcard. Next, nonetheless, comma, the authorities are permitted to go ahead with the process of go to the process of recruitment. However, the appointments to the posts as indicated it will be only one post now, Bharipur College. Only one
Yes.
college is given advertisement.
Right now, only one college. So
yeah.
let one post be kept
The
vacant.
Great,
Your Lordship.
one junior assistant with impact grade 3.
Shall be kept vacant.
No. In which category you are? SC category.
SC category.
In SC category shall not be filled up without the order of the court.
Your Lordship, there is a problem. Now the last date is gone, Your Lordship.
Then we can't help it. Then you can't help it. It can't be filled up. That's why I'm.
Therefore, I'm requesting paying before Your Lordship.
This is something which I am not prepared. I have my own reasons. Because it would amount to negating the order of the Supreme Court. You can have the hearing tomorrow, but day after tomorrow I have personal difficulties. I otherwise don't try to work.
No, it's not that. I'm not saying that, Your Lordship.
Because I have the I had the pleasure of sitting in the court up till 8:30 at times.
Your Lordship can pass the order to balance the equity in favor of
No,
both the
no,
parties.
no.
Then Lordship, particular advertisement was issued on 15/3/2023, Lordship.
No, that is okay.
Lordship, he is
That is
approaching.
okay. He has come in time.
Lordship.
There's no.
Lordship,
He has filed on 28th March. They'll have to take some time.
Lordship.
I made a mention, therefore it was listed.
It's okay. I'm not blaming you.
Lordship.
Your Lordship, the only thing to balance the equity, Your Lordship, I'm saying it that let the one post be kept vacant. Immediately after opening, the hearing may take place, then Your
No,
Lordship.
you see, Mr. Sinha, for you, it is so easy to say, please take up the hearing. Only I know my roster, how much
No,
it
I'm
is.
not saying that Your Lordship will take up immediately at my convenience.
No.
Definitely as per the convenience of
No,
this
you see,
honorable
that,
court.
no. You see, that convenience will not come. After all matters are being adjourned after vacation. I don't have a free slot. Every day, more than 50 cases are already listed.
But Your Lordship will appreciate one fact of the matter that this orders, there is a judicial order restraining something rightly or wrongly, but that order has been flouted by this
No, you see,
college.
but I am giving you an option. You can have a hearing, but that's something you are not taking up. This is an order. Then we take up the matter tomorrow. Tomorrow it will be listed. Next, the Learned Counsel for the petitioner applicants has submitted that in the meanwhile the last date for applying has expired. Post according to the under such compelling circumstances,
Your Lordship can
the
direct the
court-
college authorities to accept my application in that case.
yes,
If Your Lordship,
Yes, sir.
Lordship can always direct that.
okay. Under such compelling circumstances, the court is inclined to also provide that in the event the petitioner applies for the said post, the college authorities shall entertain the application and the same shall not be rejected for delay in applying.
Lordship. And Lordship, simultaneously petitioner may approach the authority for condonation of the.
That I've already provided.
Lordship, Lordship, Lordship.
Next, this is the matter for out of turn hearing. Connected petition for out of turn hearing on. Okay. Three five.
Lordship.
3/5/2023.
Your lordship, can it be on 5/5, your lordship? 5/5. Deeply obliged.
Five.
Deeply obliged.